the attorney for that with Mr. Board's permission and consent. Is that correct, sir? Yes.
And your name, sir?
Cortez.
All right, so your client pled guilty to operating while visibly impaired. That was on August the 19th. The operating while intoxicated was dismissed. Oh, sorry about that. The operating while intoxicated was dismissed, and he also pled to 5 over and ISS fines and costs on that in the amount of $135. Have you had a chance to review the report with him, and are there any material additions, corrections, or deletions?
Mayor, I have received the substance abuse screening, the assignment of recommendations. I have an opportunity to go over that with Mr. Gordon. There are major additions, corrections, deletions, just some updates.
Okay, go ahead.
On the status of employment, at the time of the report, he had been terminated from his prior employment. He was a truck driver, given the situation. But he has since, in the last couple of weeks, started with Amazon and is working for them, and it's also going to be DoorDash as well.
Okay. I'll modify the report in that aspect. Anything else?
No, just elocution.
Sure.
Your Honor, before you say a 25-year-old individual who in very good health. He doesn't typically drink, maybe twice a month at that, a couple of drinks here and there. This was a situation where he had a little too much and thought that he was in a good situation to drive. And he doesn't deny that. He accepts full responsibility for that. He understands that this cannot be substantial. It's a worse situation for both the reasons. He does help out financially with his family. He's a very family-oriented individual. He does help out with the rent and the bills. Plus, he's the youngest, most strapping individual in the house. He's the guy who takes care of all the everything physical, taking out the trash, the outlet, and this stuff. He also is community oriented. He does collect supplies for the local homeless shelter there in there's a program, him and a couple of guys got together, I think, go around because there's a lot of physicality to it. People see them, hey, make donations. Well, that's great, but a lot of donations become heavy, and somebody needs to be in person to help move those. And him and a few of his friends have taken it upon themselves to be those guys to deliver those. So he does do that as well. Your Honor, we just asked him to adopt the recommendation. His needs for obviously February 2, they suggest, and we agree that alcohol education to be important. Definitely at a 25-year-old age to just make sure you understand going forward that there's a lot of responsibilities with the ability to drink and legality that we can drink and that responsibility we drink. And he understands that, and I think that class would further instill those values into him. So we ask that you adopt the recommendation.
Okay, sir, is there anything that you would like to say?
No, sir, I was everything discussed.
All right, I'll adopt it. 8 months probation. You're still living in Ohio, right?
Yes, sir.
You can leave the state without the consent of the court. You cannot violate any law or ordinance if you change your address, place of employment, or home telephone number. You must notify probation. You have to report as directed. No alcohol, no marijuana, no illegal controlled substances. Kratom, poppy seeds, and CBD oils are prohibited. Consuming food or other items containing those substances will be deemed a violation. I'll order that you attend a level 1 alcohol education program. Your lawyer's right. I mean, you scored in category 2, which tells us you don't have much of a problem. And the victim's impact pin, which is one night put on by Mothers Against Drunk Drivers. I'm going to order that you serve 3 days jail, credit 1. I'll let you serve the 2 on by way of community service, 16 hours community service. I'm going to give you until October 18th to complete that. 300 fines, 250 costs. $75 victims' rights fee, $50 justice assessment for $675. Screening fee is $60 for $735. $160 in probation fees for $95, plus $150 in cost of recovery. So it's $1,045. If you violate, your probation could be revoked. You could be incarcerated for 93 days. You have 21 days to appeal. You have 14 days to apply for a court-appointed lawyer for purposes of appeal. And also, you may be eligible for early discharge. So you stay out of trouble, get all this done in 4 months by statute, you're entitled to early discharge. Do you understand everything I've said?
Yes.
Does he have all this to pay, Mr. Slavin?
But as far as his ability to pay, they,
No.
How much do you have today?
About 400.
You pay 400 now. Can you pay 50 per week, do you think?
Yeah.
You get paid weekly or bi-weekly? I mean, I'll tell you what, I'll just make it $65 bi-weekly, okay? And I'll start that beginning on September the 21st. And if you don't have the money on any of your dates that you need it, you just call the court, go on Zoom. I'll be glad to give you an extension. You seem like a nice young man. I am concerned that you're in here like, at a young age, and you already paid the fines and costs on the speeding, correct?
Oh, yeah.
Okay.
That one. Yes.
Judge, I'm not showing that the speeding ticket's paid.
You didn't pay that yet?
You mean the one you gave me for a week to pay for it? The one that was a week to pay for it?
Let me see.
I thought I ordered you to pay it at the time of the plea, which was back on August.
No, we set it for today's date, I believe.
Oh, I didn't assess costs on that? I wrote it down.
No,
On file C, you're gonna pay $135.
Oh.
$135. So I'll just have you pay that today. You'll pay the speed today. You must not have set it. And in the end, we pay $265 now on the impaired charge, and it's $65 bi-weekly starting September the 21st, okay? Wish you well, good luck, stay out of trouble. You don't want another one of these ever again in your life, okay? Good luck, thanks a lot. You have a good day, Mr. Slavin. Mia Faith Robinson, 26W843927.
Good morning, Your Honor. Deanna Teal, 8278 on behalf of Miss Mia Robinson, Station Delivery.
Your name, ma'am?
Mia Robinson.
All right, so she pled under HIDA, the child endangerments. I ordered a pre-sentence report. Have you had the opportunity to review the report with it, and are there any material additions, corrections, or deletions?
We have had an opportunity to review the report. Your Honor, the only material change is that she is not employed right now. She just gave birth last week. So
Congratulations. All right, what else? I'll modify the report in that aspect. What else would you like to tell me?
Other than that, no other additions, deletions, or corrections, Your Honor. Ms. Robinson is very apologetic for the situation. She's very happy that nothing happened while the child was at home, Your Honor. I would ask if the court would adopt the recommendation. I would ask if the court would consider a shorter probation, maybe 6 months, just time for her to complete that parenting class. But it is my understanding she should be eligible for early termination as long as there are no violations.
The prosecutor's going to have to move to dismiss this. I just want to be clear. Okay. I'm saying if whatever I give her, I'm not going to dismiss it. The prosecutor's going to have to move to dismiss because it was agreed, the agreement was to be taken under HIDA by the prosecutor. So I don't have a problem, but she's still going to have it set for a review hearing date and make sure Woodhaven's attorney doesn't have a problem with moving to dismiss, okay?
Thank you, Judge.
Ma'am, what would you like to say? Anything? See, listen, you seem like a really nice kid, but you gotta use your. I mean, you left a 1.5-year-old at home, right? You can't do that. You'd have never forgiven yourself if something happened to that child. I mean, come on. 12 months probation, you cannot leave the state without the consent of the court. You cannot violate any law or ordinance. Change your address, place of employment, or home telephone number. You must notify probation. You have to report as directed. I'm going to order that you attend and complete a parenting program through the guidance center. I'm going to order that you serve 5 days of community service. You were in custody for a few hours, correct? Yes? Yes?
Yeah.
6 days jail credit, 1 served 5, and I'll let you serve that by way of community service. 40 hours community service, I'll give you until November the 15th to complete that. 100 fines, 150 costs, 75 victims' rights fee, $50 justice assessment. That's $375, screening fees 60 for 435, probation fees are $240. Your total $675. If you violate, your probation could be revoked, you could be incarcerated for a period of 90 days. You have 21 days to appeal, and you have 14 days to apply for a court-appointed lawyer for purposes of appeal. Do you understand that?
I understand.
All right, we're going to give her a review hearing date, if you would, please, Heather, sometime at the end of August next year, middle of August,
That'll be August 25th of 27.
at 8:30 in the morning, okay? Now, does she need time to pay this, or can she,
Yeah, she needs a payment right
do you have anything with her?
now. Judge.
All right, how much can you afford to pay? I'm not talking about today, I'm talking weekly, bi-weekly, monthly, whatever you can afford.
Maybe $40.
Okay. $40 bi-weekly will start this beginning September the 21st. If you ever need more time or you find yourself not having the money, no problem. Call the court. We'll go on Zoom. I'll give you an extension. Just don't ignore me, okay? All right, I wish you well. You'll meet with probation. Thank you very much and have a good day. Miss Teal.
Thank you, Judge.
Rogers, Austin Sean Rogers, 25W402889 B and A. All right, who's here on this one?
Morning, PM EST 82378 on behalf of Mr. Rogers, station.
Austin Sean Rogers.
All right, so he's going to plead on file A to allowing unlicensed driver to drive, correct?
Yes.
And then he has the judgment entered on file B, which he's going to have to take care of. If you plead guilty to allowing unlicensed driver to drive, possible penalties are up to 500 fines, 90 days jail. Costs are all those that will not get reported to the Michigan Secretary of State. Do you understand that?
Yes, Your
And did you sign, read, and understand the advice of rights?
Yes.
You plead guilty, you'll be giving up all those rights, so we're not going to have a hearing or a trial. Do you understand that?
Yes, Your Honor.
All right. Charge allowing unlicensed driver to drive, how do you plead?
Guilty.
Were you on I-75 northbound in a 2010 Mercury near Weston Woodhaven, October 2nd of 25 at 5:20 p.m.?
Yes, Your
And
Honor.
were you in control of that vehicle, and were you suspended, revoked, or denied at the time?
Yes, Your
Are
Honor.
you on probation or parole?
Yes.
Anybody force you to plead guilty?
No.
I'll accept your plea, dismiss the suspension. What do we have here? What's he doing? Where is he done? He's got a valid license at least now, but why wasn't he here again for a year? Man,
I was in Wisconsin working, and when I called you guys at the time, we weren't doing the Zoom meeting, I had to basically come in for that.
well, did you tell me we're in Wisconsin working?
Yes.
They wouldn't have denied you that. What else, counsel? Anything?
Your Honor, he's been gainfully employed, as Your Honor can see, his license is now valid. He is, I know Your Honor may see the warrants in the file, he's working through all of those warrants, he's currently on probation and.
That was for all my addiction, Your Honor.
What's that?
That was, all those warrants was for a span and a half of 2 years when I was going through addiction. I've been sober for a year and a half, and now I'm taking care of everything. I just took care of Garden City yesterday, I have to go get them $100 payment today.
Anything else anybody wants to say?
I want to tell you, Your Honor, he's just actively working through everything.
He owes $213, right, Heather, on the speeding charge?
I can pay that today.
That actually has a balance of 248, Judge.
$248. On this case, 100 fines, 125 costs, 75 victims' rights, $50 justice assessment, 350 or 90 days. You can pay the speeding today.
I could pay 218 of it. I have 220 in my pocket or on my card.
Pay 215. Balance is going to be waived, Heather. We'll waive the balance on that. one.
Okay,
And then on the other case, I'll let you pay. You can set up your own payment plan. What do you want to pay?
I'm at 50 a week.
50 a week, starting this 14th of September. If you ever don't have the money, no problem. Call the court. We'll go on Zoom on or before that due date. I'll be glad to give you an extension. Just don't ignore me, okay?
Yes, Your Honor. Thank you.
Good luck. I'm glad you're getting your life in order. It's not, All right, good luck.
Thank you, Judge.
Thank you. People against. Purdy, Austin Jack Purdy, Hughes. 6W842221. Where's Mr. Purdy? Your name?
Morning, Your Honor. Austin Jack Purdy.
You were gonna hire a lawyer. Did you hire a lawyer?
I wasn't able to walk at that time, so I had a court of labor.
All right, I'll give you a lawyer. You're entitled to one, never arranged, so we'll go ahead and give you a lawyer. And you will come back, your lawyer will meet with the prosecutor. And then you will come back in here, okay, with your lawyer. Any questions?
So take a seat in the hall.
I need some white out down there. Yeah. Yes, you could take a seat in the hallway and then you'll come back in here with your lawyer. Thank you.
It needs a fast start.
Priority Waste Inc. 267843910. Ms. Trombley, good morning. Your name?
Good morning, Your Honor. Elizabeth Trombley appearing on behalf of Priority Waste.
All right, public nuisance. Wow, 110-106. They're pleading this to that. They're dismissing the spill load. Prosecutors agreeing to, and apparently you're agreeing to pay, your client is on $500, true?
Yes, Your Honor.
All right, you're authorized to enter this plea on behalf of the company.
Yes, Your Honor.
Charge of public nuisance under Woodhaven Code Section 110-106. How do you plead?
Responsible.
All right, I'm going to accept the plea under that section, dismiss the original charge of spill load. Fines cost $500. I'll give them until October the 2nd to pay, okay?
Thank you, Your Honor. Have a good day.
You too. Thank you very much.
Thank you.
Bye now. Kayana, Precious Al Higgs Carter. 6784222 and B. All right, next will be Grant Satelli. Your name, ma'am?
Good morning, Your Honor.
You're charged with misuse of a credit card and concealing stolen property. You have the right to a lawyer. Would you like one? All right, we're going to set you up with a defense attorney. You can go out in the hallway. You'll meet with the lawyer. My court officer will set you up. He or she will talk to the prosecutor, and then you'll come in with your lawyer after that, okay? Good luck. Nicholas John Grant Satelli, 26B1496738 and B and C. Who has Mr. Grant Satelli? Oh, you're Mr. Grant Satelli. Your name?
Nick Grant Kelly.
You have a drive while suspend, improper plate. Yep, and you also have a contempt hearing on a civil infraction. You have the right to a lawyer. Do you want one?
Yes, sir.
I'll give you a lawyer. You're all set. Go out in the hallway and we will take care, we'll set you up, okay? All right. Jeez. Dmitro Panasiuk, 267844195. Mr. McDermott, your appearance.
Good morning, Judge. Sean McDermott on behalf of Mr. Panasiuk. We do have a resolution. I do have authority to plead to the amended charge of impeding traffic.
All right, you're authorized to enter that plea on his behalf.
I am, Judge.
To that charge of impeding on his behalf, responsible or not responsible?
Responsible.
Please accept it. 220 paid by September 9th.
Will do, Judge. Have a good day.
Hey, you too. Thanks a lot. Bye now.
Take care. Bye.
Thank you. RLV, I'm sorry, looks like, or RLV SRAM, 267843837. Good morning, Mr. Grant. Your appearance?
Good morning, Your Honor. Appearing on behalf of the same guy that I butcher his name as much as you do.
Your name?
David Grant appearing on behalf of RS Ram.
All right, you're authorized to this plea on his behalf to impeding. They're going to dismiss the prohibited truck route. True?
I am, Your Honor.
To that charge of impeding traffic, responsible or not responsible?
Responsible, Your Honor.
All right, I'll accept the plea, dismiss the prohibited truck route. 220 is the total, paid by September 9th. Have a good day. Thank you.
Your Honor, if I may be so bold, this is probably a broken record, but I'm not driving.
Yeah. Have a good day. Take care.
You too.
See ya. Al, Aladdin Adel Ahmad Obey, 26W843-201. Good morning, Mr. Gazdecki. How are you?
Honor, how are you today?
Not too bad. Your appearance?
Mark Gazdecki, P 46289 on behalf of Mr. Obey for his permission, Your Honor.
He was defaulted. You filed a motion to set aside default judgment. I set it for hearing today, and the prosecutors come in now. Apparently, he agrees to it because he sent in a stip form that says that your client's going to plead responsible to 1 to 5 over limited access.
Correct, Your Honor. We posted a bond.
Right. And so you're authorized to enter into that plea on his behalf?
Yes, Your Honor.
All right, to the charge 75 and the 70 limited access fee, how do you plead on his behalf? Responsible or not responsible?
Responsible, Your Honor.
All right, I'm setting aside the default judgment. By implication, he's indicated he has no problem. But he's got to slow down here a little. I'll accept the plea to 75 and a 70. Dismiss the original charge. What was his bond posted at, Heather?
175, Judge.
All right, fines and costs 175. We'll apply the bond. Tell him to slow down, will you please, Mr. Gazdecki?
Thank you, Your Honor.
Have a great day. Thank you.
Always a pleasure.
You too. Singh, people against Karendeep Singh, 267-844-258. Good morning, counsel. How are
Good
you?
morning. I'm doing great, Your Honor. Thank you for asking. I'm on behalf of Rami Hijazi, P82830, on behalf of Mr. Singh.
So this is going to be a plea to, let me just double check here, impeding traffic, it looks like, with a 1 to 5 over.
Yes, Your Honor, with full authority.
What's that? I didn't hear you. I'm sorry.
With full authority, Your Honor, I would like to tender a responsible plea.
Plea is accepted to impeding traffic, speeds dismissed. This is a commercial vehicle. 180s is total. I'll give them till the 9th to pay, okay? Have a
Thank you,
good
Your Honor.
day.
You as well.
Thank you. Morning, Ms. McRipley. How are you? Nice to see you. How you doing there, Miss Tepe Epperson? What are you here on?
Judge, I'm just trying to chat with her to see if she'd like to meet with an attorney. I'm not getting a response. So if we could find out if she'd like an attorney, that'd be great.
I spoke with one yesterday, so I don't know. Do I need another one for today? If so, can I have the same one?
We won't have the same one here
lawyers here
today.
every day. I'll be glad to give you one. Why don't you put her in a breakout room with whoever we have today, Heather?
Okay, and then if John could just get the file to one of our attorneys.
John, so you're gonna need to get Epperson to a lawyer.
Just accept that invite, please, Miss Epperson.
Tiffany Epperson. All right. Do you guys have anything? What's your name again, sir? Al what?
Hal, Dustin Hal.
Oh, Dustin out?
Yeah, he came to my property.
Yeah.
I got it.
And what are you here on, sir, man? No. I understand. But what are you here on? What's your name?
Joseph Patrick.
Do you have that?
I'm sorry, I was writing down something. Who?
Spell your last name nice and loud. You gotta, you.
AWLS.
Oh, Rouse, Rawls. Who should have that one, Heather?
What was the name of that one? I'm sorry, Rouse?
Joseph Rawls, Rawls.
What time is that one scheduled?
What time your case scheduled?
I don't see it on the docket, Judge.
Yeah, either do I. All right, let me look and make
What-
sure they're in the right courtroom. RAW.
9 in here?
I think he has a retained attorney, Attorney Green.
Oh. Attorney Green? Oh, okay, where'd Mr. Green go? I saw him sitting right here, right?
Oh, he's hyphenated, Godfrey Rawls. I see him now. He has Attorney Green.
Okay, good enough. Thank you. See? You should come in here and keep an eye on us every day. That's good. All right.
Judge, here's your whiteout you wanted.
Yeah, thank you. Thank you. Dustin Lee Houdt, 267-841-1057. Did you meet with the prosecutor yet?
They told me to come back in here.
Your name?
Yes, Your Honor.
Can I see you in here and Dustin Houdt, please?
You bet.
All right, so you talk to him, but he didn't send in, he just told you to come in here, the prosecutor?
Yeah, they told me I had to see the lawyer.
Your appearance? Uh-oh. Tell me this is resolved. Your name?
Good morning, Your Honor. May it please the court, William Nurick on behalf of the city of Woodhaven.
Your name?
Laura Jensen, City of Woodhaven Ordinance Officer.
Did he do everything?
I'm sorry, Judge.
Did he do everything he was supposed to do?
According to my code enforcement officer, he did not, Your Honor. We do have some exhibits that might illuminate the present status of the property.
Okay, can you hand those up?
Sure.
Mr. Houdt, you're not gonna make me put you in jail over this thing, are you? Do you want, maybe I should give you a lawyer. Would you like a lawyer to represent you?
I did everything on the.
No, I didn't ask you that yet. Would you like a lawyer to represent you?
Yeah.
All right, we're gonna get you a lawyer. John Gibbons' lawyer.
Yeah.
I'll hand you these back right now. You hold on to these. You can share them with the defense lawyer, okay? All right, thank you. Give him a defense attorney. Please. Mr. Green, is your case ready?
Yes, man, good morning. How are you?
Not bad. Yourself?
Pretty good. I haven't seen you in a while.
I know, you doing all right?
Yeah, I'm just coming out here.
Well, good. That's good to hear. We miss having you here.
Thank you.
Did you work out the case with the prosecutor?
I did.
Did he bring the file in yet?
I don't think he did. I thought he
I
did.
have a file.
We don't have a file. Go get the file from him and I'll be glad to get you out of here, okay? Joseph.
Sure, do you like to see a minor?
All right. All right, people against Joseph Sharon Godfrey Rawls, 267-844-419 A and B. All right, good morning. Your appearance?
Case of court, I'm Robert K. Green, P 33837. I'm representing Mr. Board of Fire for standing to my left.
Your name, sir? All right. He's going to, first of all, does he stand mute and wait formal reading?
Absolutely, Your Honor.
All right, so now we've got a contributing to the delinquency of a minor charge. And they're going to dismiss that. and he's going to plead the public nuisance under section 110-106, which is a civil infraction, correct?
Yes, Your Honor.
And then they're also going to dismiss the defective equipment. All right. Is that what you want to do, sir? You got to keep your voice up for me.
Yes, Your Honor.
You're well-spoken, good-looking kid, but you're well-spoken. Keep your voice up. All right. To the charge of public nuisance, responsible or not responsible?
Awesome.
Okay, I'm gonna accept that plea, dismiss the original charge of contributing to delinquency. So they were vaping with two minors, allowed 2 minors under 21 to smoke marijuana vapes and nicotine vapes. 175 is your total. Anything else?
Nothing else, Your Honor.
Have a good day, Mr. Green. Good to see you. You can pay that now?
Can you get there? Can you put my?
Where do you work at?
I have to.
Okay. Mr. Green, he's very
It's
focused.
like a management company.
When can you pay it? Can you pay it a week?
2 weeks, Your Honor.
Yeah, 9/16. You can do that? Yes?
Yes, Your Honor.
All right, make sure you come in by that date. If you don't have the money, no problem. Call the court. We'll go on Zoom. I'll give you an extension, or you can walk in here on or before the due date at 8:30, but just don't ignore me, okay? Best of luck.
Thank you, Your Honor.
Judge,
Thank you. Have a good day. Good luck.
did you say 175 for that, and then the defective equipment was also dismissed?
Correct. They dismissed the
Okay,
defective
thank you.
as well. Yes, by the 16th of September, he's gonna pay that.
Thank you.
No problem. Do I have any other files down there?
No.
Okay. Can you talk to him yet, counsel?
Yes, Judge, she's okay with the impeding traffic on my file upon your approval.
Okay,
Thank you.
did he?
Hi, how are you?
Listen, could you send Lieutenant Toller in with Tabash's file? I've got his lawyer waiting here and I'm gonna get off the bench and I don't want to keep him waiting. If it's written up. Thank you. Bye.
Morning, Your Honor.
Good morning to you. How are you?
Good, sir. Thank you.
Thank you.
All right. People against Sabah Jamil. I think it's Safio Habash, 267-844-274. Good morning, counsel. Your appearance?
Good morning again, Your Honor. For the record, Ziad Nicholas Abu Zaid, P69447. On behalf of the defendant, I ask that you waive his presence on the civil infraction matter.
You're authorized to enter this plea to impeding on his behalf with the speeding to be dismissed, right?
Yes, Your Honor.
All right, tell him to slow down. It's a commercial vehicle. He's got a couple priors to that charge, impeding traffic, responsible or not responsible on his behalf.
Responsible, Your Honor.
I'll accept the plea, $200, September 9th, okay? You can pay by September 9th.
Thank you, Judge. Good to see you.
You too. Have a great day. Thank you.
Thank
Court's
you.
in recess.
Yeah. I had to like get ready for this. Good morning, Judge. John Gatsiani.
All right.
Epperson.
So I have Tiffany Janelle Epperson, 25W841089A, 25W395578. All right, I'm sorry. Go ahead. Your
For
appearance.
the record, John Gatsiani, appearing on behalf of Tiffany Epperson, Judge.
Ma'am, your name? You have to unmute and tell me your name, ma'am.
Oh, Tiffany Epperson.
So as I understand it, she's going to plead guilty to both charges, no ops. They're going to dismiss the suspend, right?
That's correct, Judge.
As to each one of these. Is that what you want to do, ma'am?
Will you, I mean, I guess so, that's fine.
I don't want you to guess.
Ma'am, I explained to you,
That means that I'm gonna have like my license suspended still for like 3 months, and then after that, it'll be unsuspended?
Ms. Epperson, the court does not have jurisdiction over suspension time. What ends up happening is the Secretary of State will look at your file and they will take that determination.
Oh,
I
okay.
indicated that there's that possibility. He probably works with driving while license suspended. That's why we're able to cooperate. Control suspension.
Where are you right now?
That's
Ms.
fine.
Epperson? Hang on. Where are you right now?
That works, Judge.
I'm at work in a hallway.
Listen, if you don't want to do this, you don't have to do this. I was just reciting what your lawyer and the prosecutor worked out. If you want to plead guilty to those two charges, the possible penalties are up to 100 fines, 90 days jail, costs are all those. I haven't looked at your record. Ma'am, what are you looking at? What are you looking at?
I was making sure the door wasn't coming open. It makes noise when they open it.
Judge, she's doing her best and it's just a little bit of a background.
No, I get it.
She's going to work with a bus. She has no car.
Is this what you want to do, ma'am? If you don't, you don't have to. We'll go to trial on the drive while suspend. Those are 2-point violations, though. This is 0.
That's fine. I will take the 0 points.
You're presumed innocent. They have to prove you guilty beyond a reasonable doubt. You have the right to a trial by court or jury. The trial, you have the right to question their witnesses. Bring in your own. Use the subpoena powers of the court to bring in those witnesses. If you plead guilty, you'll be giving up all those rights, and we are not going to.
Hearing in this matter?
No, Your Honor, he wishes to tender a plea of guilty to the probation violation.
Mr. Merriman, do you understand the rights you're giving up by admitting to this violation?
Yes.
Do you admit or do you deny that you violated the terms of your supervision?
Admit.
Based upon your admission, I find you have violated the terms of your community control. Ms. Quicko, could we do one last check in the hall for Mr. Neal? Because he's been at most of our hearings, but he is not yet here. Have we heard from Mr.
I
Neal?
did go and look for him. There was no one waiting up.
Mr. View, on behalf of the state.
Your Honor, of course, familiar with Mr. Merriman. He's repeatedly been unable to comply with court's conditions of probation. This is an assault charge, a felony assault charge. I know the court has heard previously from the victim in the case and his input in relation to revocation and imposition of a prison sentence. We are in agreement with that. Our recommendation is an 18-month prison sentence with credit for 64 days of jail time credit.
Mr. Hust?
Your Honor, I realize that it is a very, very, very egregious situation. We've come to a point where, practically speaking, we're out of options. I know at one point probation was in favor of CCBF under certain circumstances, and they've changed their position on it, if I understand. However, I would like to point out that AJ is interested in doing something like that. I had a very candid talk with him last night about this situation and how egregious it's all been, and it's come to a point where there isn't much to do, and he realizes he's got to submit to a tougher, more demanding alternative. So I would like to make that suggestion at this point, that we try a lockdown facility. Again, I realize the situation, but at least for the record, I would like to make that recommendation. Thank you.
Mr. Merriman, anything you want to tell me?
I just want to say I've in the past year or so, I've really battled with addiction. It's been a big problem for me. I really I really didn't want I wanted to finish probation. I thought about checking into rehab a few times, but I didn't know if there would be any consequences for doing so. But if I'm given the chance to go to a rehab or a CCBF, I would do that. I would complete it.
Here's the thing, Mr. Merriman. We've been here a bunch of times. And just doesn't seem like you're doing the things that you need to do. And at some point, Mr. Merriman, I need to vindicate the system. That has to happen at some point. And we are at that point now. I find that you are not amenable to community control. I am going to sentence you to 14 months in prison. I'm going to give you credit for the 64 days that you have already done. There might be some opportunity for you to receive credit of up to 1 day per month for participation in certain vocational or educational programs that are sponsored by the Department of Corrections. You might also be eligible for some sort of transitional control, something like that. I think for a 4th-degree felony, they still ask me, but my position is always the same, Mr. Merriman. If you and the prison want to work something out, I don't care about that. So if you're going to sign on for mandatory post-release control, then that's okay with me. I'm not going to stand in the way of that. It doesn't make sense for me to continue to supervise you. I don't think that I would consider you favorably for judicial release, even though technically you are eligible. This also includes the optional period post-release control of up to 2 years. We have 64 days of jail time credit. Anything else we need to do? Anything I forgot?
No, you're not.
All right, you do have the right to appeal this, Mr. Merriman, to the 12th District Court of Appeals in Middletown. If you don't have the funds to hire a lawyer to obtain a transcript or to pay the costs, they will all be provided to you at no charge. Good luck to you.
Thank you, Your Honor.
To have a hearing or a trial of any kind. Do you understand that?
Yes.
All right. Is this what you wish to do?
Yes, that's fine. Yes.
To the charge, no valid operator's license on person with regard to the August 1825 incident. How do you plead? Guilty or not guilty?
Guilty.
To the charge of no operator's license on person with regard to the December 26, 25 incident. How do you plead? Guilty or not guilty?
Guilty.
On August 18 of 25, were you operating a motor vehicle on Western or northbound I-75 in Woodhaven at 11:08 p.m.? And were you operating a vehicle on that date and time?
Yes.
Did you have a valid operator's license on your person?
Yes.
You had a valid license on your.
You did not have a valid license.
Well, the first one I got suspended for was no insurance, and the second time was for no license. Because they suspended me because of the no insurance, I believe.
Just answer my question. They wrote you for driving on a suspended. Did you have a valid license on your person at that time that was absolutely valid with the Secretary of State?
No.
I'm not sure. I guess no. But I'm to my knowledge.
I don't want you to guess. This isn't Jeopardy. Listen to me. I'm sorry. I'm going to have you come in here. I'm not comfortable with what's going on here. I don't want you to be guessing. I don't want to talk to people in stairwells. You need to come in and talk to this.
Judge, I think she's really misunderstanding. She's very nervous because of the fact that she's at work. She started this position about a month ago. She only works a couple of days a week.
Well, I can't. She's telling me she had a valid license, though.
Judge, I explained to her. I indicated everything. You did not have a valid license because you were previously suspended for unpaid tickets in other jurisdictions. Is that correct? Yes or no?
Well, I was told that Woodhaven suspended my license. I was like, they told me that Woodhaven suspended my license.
Ma'am, I'm asking you, listen to me. On August 18, you were driving and they wrote you a ticket for driving on a suspended license. At that time, was your license suspended?
Not to my knowledge, no.
All right.
They wrote me a ticket for having no insurance. And then I had called the clerk to find out, and she told me that they suspended it for not having insurance. Because I called
Yeah.
Detroit to make sure that it wasn't suspended and I
Was it
paid that
suspended
ticket.
was it suspended before August 18th or not of 25?
No.
Okay. Well, I'm gonna have to reschedule the pretrial. And I just need you to come in. You're gonna have to look at this paperwork with your lawyer. And that's what we'll do. Okay, so we'll reschedule the case. Won't take a plea now of any kind. The drivewall suspended on both of those, which are 2-point violations. Those charges will remain in full force. And then we'll go from there. And if you're not suspended, I don't want to take your plea to anything. Okay, so that's what we'll do. We'll reschedule the pretrial. What do you have for me, Heather?
September 16th at 8:30.
September 16th at 8:30. That will be in person, okay? In
Do you
person.
have like any days on like Tuesdays? Because I do work on Wednesdays and I'm only here 2 days a week. So I would try to get these hours that I can get.
I want you to get the hours, but Woodhaven's only here on certain days. They're not here on Tuesdays.
Okay.
Thank you.
So you have to appear in person, ma'am, 9/16 at 8:30, okay?
Okay.
If I could accommodate you, I would. Good luck.
Thank you.
Thank you. Thank you. Good luck, ma'am. September 16th, 2 weeks
thank
today,
you.
8:30. Ashley Jane Reese, 26F721794. Detective, your name?
Yes, sir. Detective Judge Oda, Flat Rock Police Department.
Raise your right hand. You solemnly swear affirm under penalties of perjury the testimony you've given these proceedings will be the whole true self you got.
I do.
All right, go ahead.
Okay, on August 30th, 2026, at approximately 11:46 p.m., Corporal Hunter conducted a traffic stop of a silver Ford Focus for a speeding violation. Corporal Hunter was dressed in a full Class B uniform with Flat Rock police patches on his shoulders and police on the back of his outer vest carrier. When Corporal Hunter made contact with the driver and sole occupant of the vehicle, Ashley Jane Reese, she admitted she had been drinking. Corporal Hunter asked Reese how much she had to drink, and Reese said enough, and then laughed at Corporal Hunter. Corporal Hunter asked Reese to step out of the vehicle. Reese walked to the front of Corporal Hunter's patrol vehicle and laid her upper body and head against the hood of the vehicle. Corporal Hunter asked Reese where her driver's license was, and Reese said, "I don't have one. My license is suspended." Corporal Hunter asked Reese what she had to drink. Reese said a 4 Loko and a 5th of Pink Whitney vodka. Reese then added that she is currently on probation in Monroe County. Officer Murray arrived at the traffic stop wearing a Class B uniform with Flat Rock patches on each shoulder and police on the rear of his outer vest carrier. Corporal Hunter asked Reese to take a PBT. Reese immediately stated that she was not taking a test. Corporal Hunter then asked Reese to take standard field sobriety test. She became angry and said that she was going to run away. Reese was then taken into custody by Corporal Hunter and Officer Murray on suspicion of OWI. Reese was transported to the Flat Rock Police Station by Corporal Hunter. Corporal Hunter read Reese her chemical test rights verbatim from the DI 177 form. Reese agreed to take the breath test. The results of that test were 0.212 BAC. While attempting to secure a second breath sample, Reese became upset and officers moved her to the back of the booking room bench. Officer Murray started the booking process and Reese began to yell and request to speak to the chief of police. Sergeant Slarb entered the booking room dressed in full Class B uniform with Flat Rock police patches on each shoulder. He began to speak with Reese and advised her that he was not the chief, but he was the on-duty supervisor. Reese said she did not want to speak with Sergeant Slarb, and then she stood up, trying to pull her hand through her handcuffs. Reese was able to slide her hand halfway out of the handcuff before Sergeant Slarb was able to grab her hand and attempt to tighten the handcuff. Reese then turned towards Sergeant Slarb with a closed fist in her uncuffed hand. Sergeant Slarb believed Reese was going to punch him, so he pushed her against the wall and backed down onto the bench. Officer Murray and Corporal Hunter came back into the booking room as Reese was becoming more aggressive. Reese began to punch, kick, and spit at officers. Reese kicked Sergeant Slarb once near his genitals and once in his right thigh. Reese then lifted her head and spit at Sergeant Slarb, with some of the saliva making contact with Sergeant Slarb's face. Officer Murray then administered a short spray of Freeze Plus P pepper spray to the face eye area of Reese's head. Reese continued to be aggressive and attempted to spit at officers. She continued to resist even when a spit mask was placed over her head. Sergeant Slarb made the decision to end the booking process and place Reese in the detox cell until she calmed down. Officer Murray and Corporal Hunter escorted Reese to the detox cell and secured her there. Reese was not able to be processed until 2:30 p.m. the following day. Reese has one prior conviction for OWI on January 31st, 2024 in First District Court. She has two previous convictions for attempted assault on a police officer from April 6th and October 26th of 2023 at First District Court, as well as a felony conviction for assaulting a police officer on August 15th, 2025 at 38th Circuit Court. Her Michigan driver's license currently suspended since June 4th of 2024, and she is currently on probation at 38th Circuit Court from October 9th, 2025 through October 9th, 27 for 2 counts of assaulting a police officer. That's all I have, Your Honor.
I've got a fleeing elude third conviction out of Monroe County of August 15 of 25. Do you show that?
Yes, I just.
And also resist and obstruct an officer, same date.
Yes.
And also drive while suspend prior conviction 131-24 out of Monroe. There's just a lot of different things going on here.
Yeah. Yes, there is.
Do you have that as well?
Yes, Your Honor, I do.
Based on your sworn testimony, I find that the crime of OWI 2 was committed. Assault, resist, and obstruct an officer was committed. Drive while suspend was committed, and there's sufficient evidence to establish that defendant had the 2 prior convictions giving rise to the habitual third offense notice. So I'm authorizing the issuance of the complaint and the warrant, and you can bring her in for your name, ma'am?
Ashley Reese, REECE.
Counsel, your appearance.
Good morning, Judge. I got Ms. Reese.
Does she stand mute, wait formal reading?
For hearing purposes, yes.
Ma'am, I'm going to advise you of your rights. You do have the right to remain silent. You do not have to say anything. If you do say something, you're out of court, whether orally or in writing, it can be used against you. You have the right to be represented by a lawyer today and at all subsequent court proceedings. And if you ever choose to submit to questioning with law enforcement issues, you do have the right to be represented by a lawyer at that questioning. Do you understand that?
Yes, sir.
You have the right to a probable cause conference within 14 days. That will be on September the 15th at 9 in the morning. Preliminary exam will be September 22nd at 11:30 in the morning. As to any felony charge, as to that, at that preliminary exam, the people have to show that the crimes were committed. That is to the only felony count, really, assault, resist, and obstruct, that crime was committed and that you were the one who probably committed that crime. If they prove that, you'll be bound over on that charge and all other charges contained in the complaint and warrant. Do you understand that?
Yes, sir.
Then you would go to the circuit court. Do you understand that?
Yes, sir.
So again, 9:15, September 15 at 9, September 22 at 11:30. Those will be in front of Judge Hess, and I'll listen to you with regard to them.
Judge, Ms. Reese is 35 years old. She doesn't have 2 minor children, which she shares custody with her ex-husband. They live with her 1 week on, 1 week off. He is currently employed at Marco's Pizza in Rockwood. She's been there for the last 9 months. Previously, she was working with me for 2 years as a coal mill cleaner. After speaking with Ms. Reese, Judge, she doesn't recall the events of that night after the initial stop. Between the time of the stop and the time that she actually woke up in the cell is completely a blank to her. She was not aware that anything like what's alleged in the report occurred. With that being said, Judge, she is able to post $600 today. The court's willing to grant her a reasonable bond with a 10% provision. And she asked for court appointed counsel.
You asking for any bond here, Detective?
Your Honor, with regards to this case, plus the assaultive history of Miss Reese, we're asking for a cash bond today.
Ma'am, I'm going to advise you of your bond conditions. You're not to have any contact with the victims. You cannot write, phone, see, text, email, or communicate with the officers or have anybody else do any of those things for you or on your behalf. No contact with prosecution witnesses except through your lawyer. So you're not to have any contact with Officer Schlarb, Murray, or Hunter.
Okay, sir.
You're not to purchase, possess, or consume alcohol. You're not to purchase, possess, or consume marijuana. You're not to purchase, possess, or consume illegal controlled substances. You're to attend AANA at least 3 times a week. He's going to hand you a form. Every time you go, you have to have the form signed. Every time you come to court, you have to bring the form with you. You're not to be released until fitted with a SoberLink device. You're not to be released until fitted with a SoberLink device. You cannot leave the state without consent. You can.
I'm sorry, sir. I didn't know what you meant.
You cannot leave the state without consent of the court. You cannot violate any law. You must appear in court as directed. $75,000, 10% will be your bond. You're going to have to post $7,500 to secure your release.
Okay.
That's it. Good
Thank
luck.
you.
Thank you.
No. Never gonna go. Usually places here, not busy.
Somebody showed up.
She was supposed to be here at 9, but she just showed up, so.
Why are you showing up at 10:20 if you're supposed to be here at 9, ma'am?
Sorry, because I haven't, that's 10, that's why I'm.
Still late.
I noticed that happened. I apologize in the middle of my.
Yeah, you can't talk from back here.
Huh?
You can't talk from back here.
Oh, I'm sorry.
Randy Bashir Reapers. Come on up here.
Oh.
26W844-122. Your name?
Randy Burns.
What you doing? What are you doing?
You talking talk.
Are you under the influence of something?
No, I'm very sorry. Maybe a little groggy.
Groggy from what?
Just woke up. But I apologize for being late. I had it. It seems that my notice might have still got lost with it with my belongings of trying to wait out the month to be here. I thought I could have sworn it was 10.
So I'm looking at it, right? I'm looking at the notice that was sent to you. It says 9.
Says 9. Oh, I'm sorry. I had it in mind 10 for some reason. Because I got up early. Just
Where do you work? You work?
job attainment has been pretty bleak. No,
You're not working?
no.
charged with child endangerment. They think you left your son outside the hotel when he was 5. You have the right to a lawyer. Do you want a lawyer? I'll be glad to give you one. Would you like an attorney to represent you? No. I'm gonna give you a lawyer. You want a lawyer?
Sure.
You okay? Ma'am, are you okay?
Yeah. Yeah, I am.
I mean, if you're not, I can reschedule this.
What makes it not okay?
I'm just asking you, I just told you if you're not okay, we can reschedule this. You told me you were groggy.
Yeah, but I'm still here, still alert. Obvious.
All right, we'll give you a defense lawyer. You go out in the hallway and we'll set you up, okay?
I've seen hallway.
You gotta be here on time next time.
I will, sorry.
You wait out in the hallway and we will set you up with a lawyer.
Okay, thank you, Your Honor.
You're welcome. Everybody stay seated, please. You all right? What's that? Sure, come on back.
Hi, how are you? Good, I haven't seen you all in a while. Yeah, I turn up every now and then.
I'm sorry, Anna. It was, that was absolutely uncalled for Razan to do that to him.
I thought he was gonna bring Alan, but
No, he's got other stuff. Court.
Really? Really?
I see him. It's just, it's gonna be a day.
Yes.
Court calls the case, people versus Tasha Steiner.
Kind of it's over on behalf of his family.
Christina Sachs on behalf of China.
Oh,
Yeah.
I thought they were students.
Okay, yeah.
Same double.
Your name, ma'am?
Tasha Steiner.
Thank you. What are we?
Oh, Your Honor, we're asking in German. We filed a plea form for a no contest, but I missed the deadline.
Gotcha. I'll adjourn the matter to September 16th, 2029 AM.
She's being held on other.
On something else? Okay. Really? We'll do it on 16th. All right. Thank you. Bond continue. Court calls case people versus Antoine Reef.
Good morning. I have Christina Sachs for Mr. Reed, who's approaching.
Morning, Your Honor.
Good morning. Your name?
Antoine Reed.
Thank you. All right. What are we doing?
Yeah.
There had been an offer previously extended in this case. We recently received some communication from the victims where I wanted to discuss with them some work before we finalize that offer. I'd be asking for about 2 weeks so we can have that conversation.
Adjourn the matter to September 16th, 2026, 9 AM.
Thank you.
All right. Bond. Thank you. Court calls the case, people versus, is it Martahia Stewart?
Morning, Your Honor. Randy Cook for the people. I saw this back. I'm not sure they do.
Okay, I saw him with stranger. Let me just
You go backwards with trade chair? What's your name?
Martasia Stewart.
Thank you. No, I don't want to hear.
Is that okay?
No, we'll wait.
Okay, yes, Your Honor, Hugo J.
I thought you weren't here because it was quiet when I came in, but go ahead.
Once again, you've heard me to the quick, Judge. You heard me to the quick. Yes, Your Honor, Hugo J. Mack appearing on behalf of Ms. Stewart. Ms. Stewart, please state your name for the record.
Martasia Stewart.
Should go.
Okay.
Go ahead.
Okay. Your Honor, I have had an opportunity to speak with the prosecutor briefly, and this is a pretrial matter, and my client has signed a waiver of jury trial right, and we will just ask the court to set it for a bench trial for the record on it.
Yeah. Ma'am, you signed your waiver, the waiver of trial by jury?
Yes.
Okay.
Bench trial.
Right. So you understand that you have an absolute and constitutional right to have the matter tried before a jury.
Yes.
You understand that by signing that form, you're waiving or giving up that right and it'll be tried before the court without a jury.
Yes.
Okay. People also waive their right?
First and paid off. That's looking for.
That's not true.
The day of.
It will not be open to that trial? Okay, so I'm sorry, what is it? What is it then?
2 weeks.
2 weeks from today. All right, so.
All right. Based upon the statement of counsel and defendant, court will consent to have the matter tried before it without a jury. Non-jury trial and will be for September 30th. Might work for you. I'm asking, I don't care, but.
Yes, sir, September. I'm sorry. No, I'm sorry.
Pretty.
Yes.
2026, 9 a.m.
Also, just for the record, I know the court's aware, but I will not personally be here for that as I'll be out of the country at that time. I'll make sure our office has someone, obviously, who can try the case should that.
All right, very good. Thank you.
Your Honor, one other matter. My client has got some other cases in, I believe, in front of Judge Washington, and I believe counsel is there. What's the other one again?
Defendant has 2 cases out of different courts, one for Judge Washington on an animal abuse case, and then a DWL as a township matter in front of Judge, I believe it was Barr. Double check, but neither of those are.
So I just want to see, what is the court holding my client on anything other than a bond?
Have her bond that because originally after the arraignment, it was set at $100, which leads me to believe that there was another hold. And then it got set for November 19th of 2025. She did not appear and I issued a bench warrant, but. Okay. Oh, it's at 5,000, 10%.
10%. So if she could get the other matters cleared up, she comes up with the $500, she could be released from.
Correct.
You see, did you understand what the judge just said?
Yes.
And Mr. Mack, if she gets those cleared quickly, then I might consider some other type of release for her. If she has those other matters cleared.
I understand.
She has to communicate with us and.
I understand, Judge. All right, Your Honor. Thank you so much.
Thank you. Thank you. Court does call the case. People versus Christina Evans. 3 cases.
Conrad Solon, Seal Town.
Good morning, Assistant Public Defender Lauren Kearney on behalf of Ms. Evans.
Raymond Cook for the people about 0577.
Miss Evans has been here every court date until now. I don't know where she is.
Go ahead, I'm listening.
Okay.
That I might have to say, no, we don't know nothing.
You know, I don't know. I have to contact her multiple times. So I have no information for her to hear, but given this is her first failure to appear in Ashford.
You're a spirit, you know. Okay, then, unless you bench warrant on the spirit. All right, bench warrant will issue in each of the cases. Defendant's failure to appear, bond will be set in the amount of $5,000 to give a 10% privilege.
Your Honor, by my record, she has failed to appear many times.
I see that also. I don't know what period I was talking about.
But in my recollection,
That would assume I was listening. No, go ahead.
at least this year that I know she's been here.
No.
So I apologize.
No, I understand. Court calls the case, People versus Michael Erickson.
Honor, it's still recommended. Townships.
And Assistant Public Defendant Nicholas Bukovich on behalf of Mr. Erickson, who is now approaching. Can you take your name for the record, Mr. Erickson?
Michael James Erickson.
Thank you.
Your Honor, we will be asking for an adjournment. We are looking to possibly resolve this matter as a result of what happens with his PCC cases.
Will the 16th work though? Or you need more time than that?
I just don't know when exactly I was not the one assigned to his PCC case, so I'm not sure exactly when those would be resolved.
You have that?
There was a PCC
yesterday.
Yesterday, right. And did I adjourn your case out, sir? Yesterday? Do you know what day?
I am not sure exactly. I'm sorry, I missed it.
September 17th.
Okay. So you want a date after that, or you?
Yeah, I think after would be better.
October 7th, 2026, 9 a.m. Yeah, I can take it.
Yeah.
Here. Court calls case People versus Terry Hayes.
Your Honor, Raymond Cook, the people. And Assistant Public Defendant Nicholas Bukovich on behalf of Ms. Hayes, who is appearing via Zoom.
All right, Ms. Hayes, can you state your name, please?
Hayes.
All right. I have before me a plea form. Indicates that the defendant will be pleading to two charges. Well, are they two stated charges?
Yeah, those are the two charges as charged.
You'll be pleading to retail fraud second degree, the 1-year offense, and to theft detection device removal, a 1-year offense. Upon her successful plea to that charge, let's see. So she'll plead to this. The prosecutor will then agree to dismiss case 17F 845 SM and 17S 846 SM. And it notes that Ms. Hayes has already pled in the case 17F1 1478 as part of this global resolution. That's the court's full understanding.
That's correct.
That's correct. Your Honor.
Ma'am, can you raise your right hand, please? Do you solemnly swear or affirm testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
All right. State your name again for the record.
Tara Hayes.
All right, Ms. Hayes, it's the court's understanding you're going to plead no contest to two misdemeanor charges. The first being that of retail fraud second degree. That is a misdemeanor punishable by up to 1 year incarceration, a $2,000 fine plus court costs. Fine could be increased to 3 times the value of the property taken. If that's greater than $2,000, that would become the maximum fine. You understand that?
Yes.
And also that you'll be pleading to theft detection device removal or deactivation. That is a misdemeanor punishable by up to 1 year incarceration and a $1,000 fine plus court costs. Do you understand that?
Yes.
All right, do you understand what a no contest plea is?
Yeah.
Okay, do you? Or did you have questions about it?
No, I don't have no questions.
Okay. Two things about a no contest plea I have to make sure that you understand. The first thing is it means that you're not further desirous or wanting to contest these charges. You understand that?
Yes.
Second thing you need to understand is that for purposes of sentencing, the court is going to treat you the same as though you had pled guilty. You understand that?
Yes.
All right. Basis for the no contest plea.
Potential civil liability, Your Honor.
All right. So, ma'am, to the charge of retail fraud, second degree, how do you plead?
Guilty.
Okay. You have the option of pleading guilty, no contest, or not guilty. So I'll ask that again. To retail fraud, how do you plead?
No contest.
Thank you. To the charge of theft detection device removal or deactivation, how do you plead?
No contest.
Now, you understand that by pleading no contest, you will not have a trial of any kind.
Yes.
All right. You signed or had signed on your behalf an advice of rights form. Is that correct?
Yes.
You have any questions regarding any of those rights?
No.
All right. You understand that you're waiving or giving up all of those rights, including the rights contained in paragraph 5, which are your trial rights.
Yes.
You understand you're giving up your right to appeal of right.
Yes.
Are you on probation or parole?
No.
Has anybody promised you anything other than what's been stated here today to get you to plead?
No.
Anybody threaten you or coerce you?
No.
You're doing this voluntarily and of your own free will?
Yes.
Court has been provided and has reviewed Pittsfield Township Department of Public Safety report for their case number 178173. Any objection to the court having reviewed that report?
None from the people?
No, Your Honor.
Based upon a review of that report, the court does find that there's a sufficient factual basis in which the court could determine the defendant's guilt of this offense. Ma'am, I do have to advise you, between the time that I accept your plea and the time of sentencing, if you commit misconduct as defined under the Michigan court rules, the court would no longer be bound by any evaluation or recommendation, and you would not be entitled to withdraw your plea. You understand that, ma'am?
Yes.
All right. Counsel, are you aware of any other promises, threats, or other inducements which have led to this plea?
None from the people?
No, Your Honor.
And have I complied with the court rule?
Yes, Your Honor.
Defense is satisfied, Your Honor.
All right. Court will accept the defendant's plea of guilty to these charges, both counts 1 and 2. Defendant is referred to probation for pre-sentence investigation and report. Sentencing in this matter will be October 14, 2026, 9 a.m.
Your Honor. In addressing the sentencing date,
Sure.
Ms. Hayes has always, the other case that she pled to was a 14A1 case, so she's already, I believe, began the process of meeting with probation. So
we give a date for her?
Yeah, so it'd be one on the 23rd. So the reason why we had this pre-trial moved up is so we incorporate for 2 days.
Gotcha.
Apologies, Your Honor.
Okay, sentencing September 23rd, 2026, 9 a.m. Or is that at 12? At 9 a.m. Okay, so we'll put that on that same date, and we'll be able to get her taken care of.
I appreciate it, Your Honor.
All right. Okay, ma'am, I need you to wait online. We're going to put you into a breakout room with the probation department so we can get the process started.
I already have an appointment with probation on the 10th at 2:00.
Okay. So
They
here's what I'm
called
gonna
me. I was supposed to have one on the 3rd, but they called and rescheduled it for the 10th at 2:00 over the phone.
Okay. I don't know if they're aware of this case. So what I'm going to do is what I said at the beginning. I'm going to put you into a breakout room so that they have note of this case. They will probably keep your appointment the same, but I need you to communicate with them. Understood?
Yes.
Thank you. Bond continued.
Your Honor.
You're welcome. Court calls case People versus Daryl Frederick.
And Assistant Public Defender Nicholas Bukovich on behalf of Mr. Frederick, who's now approaching.
Your name?
Daryl Frederick, good
Of course it is. Yeah, how are you, sir?
I'm fine.
All right, what are we doing?
Well, Mr. Frederick has some other pending matters, so we'll be asking for an adjournment in this matter to work out a potential global resolution.
I'm not sure how far out are his other cases. I know he's got some other stuff before me.
I put these up for exam on September 15th.
Okay, set it, I'll turn this out to September 16th. Why don't we do that? All right.
Thank you, Your Honor.
All right, thank you. Court calls the case of the People versus Peter Ezvezja.
People.
And Assistant Public Defender Nicholas Bukovich on behalf of Mr. Ivazak, who should be appearing via Zoom.
Yeah, that was a big breath.
Your Honor, I did have recent communication with my client. He did attempt to appear here today. He has been appearing regularly at his court dates. I do know he typically does have some technology issues, so I would be asking for an adjournment.
He doesn't have any technology issues. I won't issue a bench warrant. I'll adjourn this to the 16th.
Thank you so much, Your Honor.
Usually is here. So, all right. Thank you. Court does call the case People versus Daryl Green.
Morning, Your Honor. Look at the people on the file ending in 0249.
Senator Silver on behalf of Pittsfield Township in the other.
Good morning, Assistant Public Defender Lauren Perny on behalf of Mr. Green. Mr. Green, state your name for the record.
Daryl Green.
Your Honor, there has been a motion filed to withdraw because of a breakdown in the relationship.
All right, you have anything to say about that, sir?
Yes, Your Honor, it was some confusion about attorney. I had Attorney Brown and filed motion, and now we just come and set for court today to address it.
Sorry?
I was saying today is the first action to address the motion for Attorney Brown that filed.
Well, you understand that they're seeking to withdraw as your attorneys.
Yes, I don't have a problem with a court-appointed attorney. I just wanted to withdraw from Attorney Brown from being counsel.
Well, it's not just Attorney Brown. The whole public defender's office is withdrawing from your case. You understand that?
I don't.
So Mr. Brown and myself work for the public defender's office. Mr. Brown was covering my cases at the court knows while I was out. I came back. I did meet with Mr. Green. There are things he wants done on the case that Mr. Brown and I will not do. Strategy questions. And he informed me he doesn't want myself on the case either. So that's why I continued the motion, even though or continuing with the motion, even though Mr. Brown filed it. So that's why we're here today. If Mr. Green has changed his mind and wants myself and the public defender's office to remain on the case, that's up to Your Honor, I suppose, but that is how we're here.
Your Honor, that will be fine.
What would be fine?
To move forward with a appointed attorney. I don't want to be without an attorney, so we have even further.
Well, you won't be without an attorney. The question is whether I allow the public defender to withdraw.
And will I be provided another attorney?
Maybe. I mean, if I determine that there's a valid reason for the withdrawal, it sounds like, and this is just me listening to what was said to me, it sounds like they're giving you legal advice, side with your law degree, that you want to do something different. And they don't think either ethically or strategically that should be done, and they won't do it. So I don't know if another attorney is going to solve that problem, because you're going to be asking them to do the same thing. And I would imagine they'd come to the same conclusion.
Well, the problem with me and Attorney Brown was just lack of communication, basically. Like I couldn't reach him, and when he reached.
Well,
what we talked about.
Probably weren't listening to him, so.
Now, Your Honor, to make matters a little bit complicated, there was a felony about to go over yesterday, or yes, yesterday, it's where the public defender does represent.
There's been no motion to withdraw on that case, as far as I'm aware.
Got it.
That is true, yeah.
Same type of charge. Felony.
Got it. So what do you want me to do, sir?
I would move forward, just want to move forward with another attorney, another point.
But why is it that on your other case, you have the public defender and there isn't a problem? And on this case, you don't want the public defender? And as I understand it, it's because you're not listening to what they're telling you.
That wasn't the problem. It just was, the problem was with Attorney Brown. Like I say, lack of communication, whatever we talked about, none of it was ever addressed in the court, Your Honor.
I don't see a basis upon which a withdrawal is necessary, particularly since he has that same office on his other matter. So the motion to withdraw at this time is denied. I'll adjourn the pretrial in this matter to September 16, 2026, 9 a.m. Give you time to talk to. Thank you. Bond continued.
What's
also, you know what?
evidence? Oh, God.
I think he graduated from Cornell Law School. I don't know. Maybe I'm just hearing bad information. Court calls the case. People versus Kelly Comma.
Your Honor, ready to book for the
And I apologize to all of those at Cornell.
Great.
Yes, she. Ma'am, can you state your name?
Kelly Palmer.
All right, thank you.
You're
So,
welcome.
Mrs. Hunt, I tried to call you a couple times. Have you gotten my call and messages?
I didn't know after court you told me to call. I called up there and gave him another phone number for you to get a hold of me on. And actually, I called the public defender's office on the 25th and nobody has called me back on that either.
So
So you guys haven't been able to talk?
no,
Yes.
Your Honor, I've emailed and called many times. If I could just confirm the last 4 digits.
Okay.
Yeah.
Hang on a second.
So the number I have in my file, Ms. Palmer, ends in 0265.
Yes.
That's it?
Yep.
Okay. So what I'll do is I'll adjourn these out to September 16th, 2026 at 9 a.m. Give you guys a chance to talk, okay?
Okay, thank you.
I'm gonna send you a text message right now. So if you don't get it, then there's a breakdown somewhere, okay?
Okay, so we'll wait.
No,
No, that's okay. You were doing it right now. How are you gonna know if she got it? She's here, right? I know what you're doing, apparently. We'll just wait, because apparently that's how my day is today.
I got her message.
You got it. She got it. Yay.
Maybe.
All right. We'll see you on the 16th, ma'am.
Thank you. Thank you.
You know, only you can get away with that. Or does call the case of Vivo versus Roderick Miller.
Conrad Silver on behalf of.
Good morning, Assistant Public Defender Lauren Perny on behalf of Mr. Miller. State your name, please, sir.
Rogers Miller.
Your Honor, we have come to a resolution.
Yes, I have a plea form. indicates that in the case ending in 0119, the defendant will be pleading to retail fraud under the Pittsfield Township Ordinance, a 90-day offense. Upon a successful plea to that charge, count 2 in that case, as well as the case ending in 1947, would be dismissed. There is, got it. Prosecutor will recommend credit for time served. No restitution is owed.
That's correct. All things.
Correct, Your Honor.
Right. May I have him sworn?
Yeah. You solemnly swear in front of the testimony about the whole truth and nothing but the truth, so help you God.
Yes, I do.
State your name.
Roger Miller. Sir, it is this court's understanding that you're going to plead guilty to the charge of retail fraud under the Pittsfield Township Ordinance. That is a misdemeanor punishable by up to 90 days in jail, $500 fine plus court costs. Do you understand that?
Yes.
Still wish to plead guilty?
Yes.
And to that charge, how do you plead?
Guilty.
Now, you understand that by pleading guilty, you'll not have a trial of any kind. You signed an advice of rights form or had one signed on your behalf, sir?
Yep.
Any questions regarding any of those rights? On the podium, please look at paragraph 5. Those are your rights which are part of a trial. You understand by pleading guilty, you'll be giving up those rights as well as other rights on that.
Yes.
You understand you're giving up your right to appeal of right?
Yes.
Are you on probation or parole?
No.
Has anybody promised you anything other than what's been stated here today to get you to plead?
No.
Anybody threaten you? Of course, yeah. You're doing this voluntarily?
Yes.
Of your own free will?
Yeah.
And because you believe you're guilty?
Oh, yeah.
Yeah. All right. On the date of January 16, 2026, at the location of 3300 Carpenter Road in Pittsfield Township, Washington County, State of Michigan. Can't wait for this. Mr. Stewart, tell me what you did at the Home Depot, Mr. Clark, what you did at the Home Depot that makes you think that you're guilty.
Everything. No, took something.
You went in,
I gave it back though.
but you went into the store, right?
Right.
Tried to walk out with something.
Correct.
What'd you try to walk out with?
I forgot so long ago.
All right, but it was certainly, what did he try to walk out with?
One of the items was a hacksaw. Would you agree, Mr. Miller?
Yeah, I would agree. Yeah.
All right. And you didn't pay for that.
Correct.
And that was something that was offered for sale by Home Depot.
Correct.
And the store was open to the public.
It was.
All right. I won't advise him. Counsel, are you aware of any other promises, threats, or other inducements which have led to this plea?
No, Your Honor.
No, Your Honor.
Have I complied with the court rule?
Yes.
Satisfied, Judge.
Court will accept the defendant's plea to count 1 in the case ending in 0119. Count 2 is dismissed in that case, and the case ending in 1947 is dismissed. Sir, anything you want to say before I impose sentence?
No. No.
Sent to the court, all orders, state minimums of $125 fines, court costs, 42 days, Washington County Jail, credit 42, sir. Thank you.
All right. Thank you.
Good luck.
We'll see you next time around.
Yeah.
Yeah, take care.
24. Yeah.
Yes, sir. Court calls the case, People versus Janess Kip.
Your Honor, read the people.
Good morning. Assistant Public Defender Warren County on behalf of Kip.
Hey there, good
Ma'am,
morning.
can you state your name?
Janess Kip.
Thank you.
Yeah, we would like to send this for final settlement.
Jury, final settlement conference will be October 16th, 2026, 9 a.m. Jury selection, if necessary, will be October 19th, 2026 at 8. Both of those proceedings are in person. All right, bond will continue. Thank you, ma'am. Court calls the case People versus Kiwanda K.
Your Honor, Raymond Cook for the people.
And Assistant Public Defender Nick Buckovich on behalf of Ms. Thomas, who's now approaching.
Why is he still? Oh, okay. Your name?
Kiwana Quay Thomas.
All right. What are we doing?
We'll be asking to set this matter for final settlement conference.
Jury final settlement conference will be October 16, 2026, 9 a.m. Jury selection, October 19, 2026 at 8:30. Both of those proceedings are in person.
Thank you, Your Honor.
Thank you. On continue. Court calls the case. Bless you. That was loud. Court calls the case of People versus Richard Larson Ashbluff.
Your Honor, Raymond Cook.
Good morning, Assistant Public Defender Lauren Kearney on behalf of Mr. Larson Epsilon, who is approaching. State your name for the record, please, sir.
Richard Larson Asplund.
Thank you.
Your Honor, we're asking to set this for final settlement, please.
Jury final settlement conference will be set for October 16th. You need to take your hands out of your pockets, please, sir. October 16th, 2026 at 9 a.m. Jury selection, if necessary, October 19th, 2026 at 8:30.
Thank you, Your Honor.
Both of those proceedings are in person. Fine, we'll continue. Thank you, sir. Court calls the case People versus Matthew Wallace.
Conrad Siller on behalf of Pittsfield Township.
Raymond Cook for the people on the file ending in 1482.
Good morning, Assistant Public Defender Lauren Kearney on behalf of Mr. Wallace. State your name, please, sir.
Matthew Wallace.
Thank you.
Your Honor, on the township case, we have a resolution.
We do.
On the, which one is that?
That is 0129.
0129. Got it. What are we doing?
I'm going to dismiss.
Oh.
In a felony matter. Promise of majesty.
Keeping one's promises. That case is dismissed. Okay. And what about the other matter?
On the other one, I'm hopefully asking for one last adjournment. Mr. Wallace, as Mr. Siller said, pled up in circuit court. Mr. Cook and I are now trying to figure out how that may impact these cases and what we're going to do moving forward, given those pleas. He is scheduled for sentencing October 7th on the felony cases. The plan there is that he'll be released on the 7th.
Betty. Okay. After his sentencing.
Correct.
That he'll be released on that case.
On the felony files, yeah.
That's what's holding him?
Correct, yeah.
And 2 of the indictment, tampering with evidence, felony of the 3rd degree, as well as aggravated possession of drugs, felony of the 5th degree. State will ask for dismissal of the remaining counts, and I believe defense is asking for a PSI.
All right, Mr. Staten, is that accurate?
It is accurate, Your Honor.
All right, Mr. Lunsford, they're telling me that you're going to be changing your plea to 2 charges from the indictment. Before we get to your change of plea, I am required to go over some things with you. Okay, sir? I need you to answer out loud for me, please.
Yes,
All right. How old are you?
47,
How far did you go in school?
graduated.
Can you read and write okay?
Yes, sir.
Are you a citizen of the United States?
Yes, sir.
Has anyone promised you how the court would sentence you in this case?
No, sir.
Has anyone threatened you in any way to get you to plead guilty against your will?
No, sir.
Are you satisfied with the representation that you've received from Mr. Staten?
Yes, sir.
Are you currently under the influence of any drugs or alcohol?
No, sir.
Do you take medication that interferes with your ability to understand what's going on today? I have in front of me a document. This is called a change of plea. On the second page, on the line marked defendant, there appears a signature. Did you sign this?
Yes, sir.
Did you read this and go over it with your attorney before you signed it?
Yes, sir.
And you believe you understand what it says?
Yes, sir.
This document says you're entering a plea of guilty to 1 count of tampering with evidence, a felony of the 3rd degree. That carries a maximum penalty of 36 months in prison and a maximum fine of $10,000. The prison term is not mandatory. The second charge is one of aggravated possession of drugs, a felony of the 5th degree. That carries a maximum penalty of 12 months in prison and a maximum fine of $2,500. And again, the prison term is not mandatory. Do you understand the maximum penalties?
Yes, sir.
Now, you're also subject to a discretionary period of post-release control, which means if you're sent to prison, when you are released, the adult parole authority may choose to supervise you for up to 2 years. If you violate those rules of supervision, the adult parole authority can return you to prison for up to 1/2 of the court's original sentence. If your violation is that you commit another felony, you can be returned to prison for 1 year or the period that you have left on PRC, whichever is longer. That time would run consecutive to any additional prison time that you get sentenced to. Do you understand that?
Yeah.
Yes? But as I've said, it's not mandatory that you're sent to prison at all. The court does have discretion to place you into community control, what some refer to as probation. While on community control, you'll have rules you must follow. If you fail to follow those rules, the court has the authority to extend the term of your community control or to impose additional, more severe sanctions, which can include local jail time or prison. Do you understand that?
Yes, sir.
Now, you are presumed innocent of these charges. You cannot be sentenced or punished unless you plead guilty or you're found guilty following a trial. Do you understand that?
Yes, sir.
You have the right to trial by jury if you want. We will impanel a jury of 12 people and require the prosecutor to present sufficient evidence to convince each of the jurors of your guilt beyond a reasonable doubt, or the jury is required to find you not guilty. Their verdict must be unanimous. Do you understand that?
Yes, sir.
At that trial, you have a right to see and hear all the evidence that the state has against you. With the help of Mr. Staten, the right to confront and cross-examine each of the state's witnesses. Do you understand that?
Yes, sir.
You have the right to call witnesses on your behalf and in your defense. If any of those witnesses are reluctant to come, the court can force them to come by way of subpoena. That's your right of compulsory process. Do you understand that?
Yes, sir.
You also have the right to remain silent at your trial. You cannot be forced to testify against yourself. The prosecutor is not permitted to call you as a witness. You can choose not to testify in your own defense. If you don't testify, that will not be used against you, and I will instruct all the jurors that they are not permitted to infer your guilt nor anything from your silence. Do you understand that?
Yes, sir.
The burden of proof is on the prosecutor. At your trial, you're not required to call any witnesses nor present any defense, and if you do not, that will not be held against you. You understand that?
Yes, sir.
The standard of proof is beyond a reasonable doubt. That standard applies to each of the essential elements of each charge from the indictment. Do you understand that?
Yes, sir.
Now, you could also waive your right to a jury trial, but maintain all the other rights we've discussed. You could try your case to the court. I, too, would have to be convinced of your guilt beyond a reasonable doubt or would be required to find you not guilty. Do you understand that?
Yes, sir.
Do you believe you understand each of these rights we've discussed?
Yes, sir.
Do you believe that, do you understand that when you enter plea of guilty, you will be waiving all these rights? We will not have a trial.
Yes, sir.
And you understand that a plea of guilty is a complete admission of your guilt, and the court could proceed directly with judgment and sentence.
Yes, sir.
This is how you wish to proceed.
Yes, sir.
Ms. Tranter?
Your Honor, in addition to the facts alleged in the indictment, this occurred on July the 20th of 2026, Warren County, state of Ohio. Defendant was operating a vehicle. He was stopped for an expired tag, found to be under suspension. An inventory search of the vehicle revealed 0.21 grams of collected methamphetamine, Schedule 2, and Mr. Lunsford did admit that prior to the officer approaching, he did open the bag of meth, let it fall to the ground, and tried to crumple it up into the carpet of the car.
Mr. Staten, anything on those facts?
No, Your Honor, thank you.
Mr. Lunsford, did you hear the statement that she read?
Yes, sir.
Do you admit that what she stated is true?
Yes, sir.
And you understand all the rights you're giving up when you enter plea of guilty?
Yes, sir.
What is your plea?
Guilty.
The court will make a finding that you've made a knowing, intelligent, and voluntary waiver of your constitutional rights. The court accepts your plea of guilty, and based upon the statement of facts in your plea, the court will make a finding of guilty. I'm not going to get into the matter of sentencing, Mr. Lunsford. I'll order a pre-sentence investigation, and we will come back in a few weeks and do sentencing at that time. I need you to go back down to court services and schedule your interview. Okay? All right, thank you.
Thank you, Your Honor. I'll direct you.
Okay. Then what's my date after? You need me to go after the 7th, after the,
I think,
You could do both. Or.
yeah,
oh, okay.
yeah.
So,
Just want to make clear that he's being held, so
got it.
this,
So if I set these for the 16th, will that work for you guys?
I think so.
I believe so, yes.
All right.
We're really close, it feels like, right, Mr. Paul?
All right.
I hope so.
I'll adjourn these matters then September 16th, 2026, 9 a.m.
Thank you.
All right. Thank
He's just waiting on us, really, so he's like, sure. Thank you. Well,
Court calls the case, People versus Derek Simpson, no relation.
Your Honor, this is Mr. Hugo and Ms. Sparks.
Both of them?
Yeah, it's one on trial.
Oh. How come we always have to go find him?
Then here's the table one to very hard.
And the court has called him and he doesn't care. He's not, is he just going to take his time? What did he say to you, Perny?
he said, you turned to his client and said, we gotta go.
Yeah, okay.
Your Honor, can the prosecutor and I pose on you for just a very brief bench conference?
Do what?
Pose on you for just a very brief bench conference.
Hold it. Let me think about this. It's Cook,
Preacher,
which is just fine, and then Cracher and you.
we're gonna tag team you today.
Just this one time, Judge. Just this one time. Just this one time.
Sugar on top.
I'm prepared to sing if necessary, Judge.
You start singing, Mr. Allen's going to take you down.
Okay.
Fine.
In that case, I'm retired.
Yeah.
I'm gone private.
Hello.
Tried to find him and he
Didn't stop the bond violation hearing. In behalf of my client, he would ask to continue his liberty. Did not know that he was in the red zone, if you will. His mother was driving the vehicle, not him. It didn't stop, according to, I don't believe they stopped, but in any event. And his finance situation, he just simply didn't have the money to pay $175. So in mitigation of the bond violation, Your Honor, I would just ask the court to consider allowing my client to maintain his liberty.
if I may, Your Honor, in addition, they were proceeding to the John Lawrence Jazz Festival on 8/28. I confirmed that was the date of the festival. The tether went off while his mother was driving. He was in the back seat. And it was very chaotic when the call came in that's referenced on the report. I'm not sure that my client could hear who was on the other end, and given the nature of what was going on, I can't talk right now. It seems a reasonable response if you are unable to really understand and hear, because I've not had the privilege of wearing a tether or have it go off, but I hear it's pretty loud. One thing I would like to note is he was not attempting to go to the complaining witnesses building or
Well, the problem is that at some point, we don't know where he is. Because he hasn't contacted.
Right. I was actually sort of amazed that the police didn't continue to search for him that day. The report indicates they tried to find him, and even though he's wearing a GPS tether, they were unable to locate him. I want to make for that the report did not indicate that my client removed the tether nor the tether stopped working.
Well, they went to one location, but they weren't able to locate him.
Right, because he was at he was at the Jazz Festival. August 28th, there was it was the last Jazz Festival. I think it was Ipsy here Park, or, the Township Park. So what I would like the court to take note of is he was not trying to make contact with the complaining witness. He was not on the complaining witness's property. That's what I would like the court to take note of, and I believe it was accidental. So I'd ask the court to allow him to leave today. I've also instructed my client to go over immediately if he is so privileged to leave and go to community corrections and contact Brian Levette or any other tether agent and get their contact information, and so that we can avoid not having this happen again. Thank you, Your Honor.
Well, in this matter, the problem is that this defendant's obligation to contact community corrections. The alarm goes off. He takes no effort to get back with community corrections, to the extent that I then have to issue a bench warrant with no bond. And that shouldn't happen in this case if everything was as simple as you're indicating, Ms. Kracher. I understand what you're saying, but I don't have a way of necessarily verifying any of it, because his obligation starting being released on a tether. So at this point, what I'm going to do is I will adjourn this out to September 16th, 2026 at 9 a.m. But the defendant is remanded. His bond is revoked, so he has no bond, and we'll have the violation as well as a pretrial on that day.
Thank you, Your Honor.
Thank you, Judge.
Yeah. Okay. Wait, no, I just
Okay. Court does call the case People versus Janina Williams.
Senator Silver on behalf of Freeman Cook for the people in the filing against the one.
Good morning, Assistant Public Defender Lauren Perry on behalf of Ms. Williams. State your name for the record, please, ma'am.
Janina Williams. Hi, Your Honor.
All right, what do we do? I have a plea form in one case, but it's happening again.
I will probably, if there's a plea in the state, then I just need it.
Got it. Okay.
But please in the state.
Yeah, okay. All right, so the plea form indicates that she'll be pleading to an added count 2 of retail fraud 3rd degree, the 93-day offense. Upon her successful plea to that charge, count 1 would be dismissed. That's the court's full understanding.
That's correct, Your Honor.
That is correct.
May I have her sworn?
Okay.
John, just for the firm, what are you about to give be the truth, the whole truth, nothing but the truth?
I do. Janina Williams.
Ma'am, it is this court's understanding that you're going to be pleading guilty to the charge of retail fraud in the 3rd degree. That's a misdemeanor, punishable by up to 93 days in jail, $500 fine plus court costs. Fine could be increased to 3 times the value of the property taken. If that's greater than $500, that would become the maximum fine. You understand that? Still wish to plead guilty? And to that charge, how do you plead? You understand that by pleading guilty, you'll not have a trial of any kind. Signed an advice of rights form or had one signed on your behalf?
Did.
Any question about those rights?
I do not have any.
All right, please look at paragraph 5. You'll see a copy on the podium. Those are your rights which are part of a trial. You understand that by pleading guilty, you're giving up those rights as well as other rights on there.
Yes.
You understand you're giving up your right to appeal of right.
Yes.
Are you on probation or parole?
No.
Has anybody promised you anything other than what's been stated here today to get you to plead?
No, sir.
Anybody threaten you or coerce you?
No, sir.
You're doing this voluntarily
Yes, sir.
of your own free will?
Yes,
Yes?
yes,
And because you believe that you are indeed guilty of this offense?
I do. Yes.
Find my form here. On the date of September 18, 2025, at the location of 3825 Carpenter Road in Pittsfield Township, Washtenaw County, State of Michigan, what did you do at the Meijer that makes you think that you're guilty?
I went into the store and I took some items from the store and put them into a bag to be taken out deliberately without paying for them.
Okay. Store was open to the public at the time? You didn't have anybody's permission to take that property, did you?
No.
These items you took, these were items that were offered for sale by Meijer? All right. Ma'am, I do have to advise you that if I accept your plea, between the time of my acceptance of your plea and the time of sentencing, if you commit misconduct that's defined under the Michigan court rule, you would not be entitled to withdraw your plea and the court would not be bound by any sentence evaluation or recommendation. You understand that?
I do.
All right. Counsel, are you aware of any other promises, threats, or other inducements which have led to this plea?
None from the people?
No, Your Honor.
And have I complied with the court?
Yes, Your Honor.
Satisfied, Your Honor.
All right. The court will accept the defendant's plea of guilty to count 2. Count 1 is dismissed. That is in the case ending in 0181. As to the other matter, Mr. Schiller?
Your Honor, based on in this case.
Okay. That case is dismissed. Defendant is referred to probation for a pre-sentence investigation and report.
And I will say, Your Honor, if probation is here, she is going to Oakdale. I heard from Patrick in the jail today that they have a bed for her.
Ooh.
And she's going this week. So I know we're very happy about that. We've been waiting for a long time. So I discussed a release of information, but if probation is listening,
They're always listening.
that's where she'll be for the next however long that program is, at least 30 days.
All right.
Yes,
Excited about it.
I am.
It has been a wait for you.
Yes.
So I'll,
Very helpful, Your Honor.
pardon?
It's been very helpful at the same time.
Yeah. You'll get there.
Yep.
Right?
Yep.
Sentencing will be. Well, what's her bond in this case? What else is holding her? Anything else? Or just this?
She has 2 felonies in circuit court, 3 felonies. Kind of, Judge Slay is also waiting for the treatment thing too, I think.
Got it.
Yeah.
Here's what I'm going to do, okay? Because I don't necessarily want to interrupt your treatment by next October 14th. I'm going to set her sentencing for October 14th, 2026, 9 a.m. What I'm hoping is she'll be able to get through the program. We'll figure out where she is. If this Miss Parody becomes the only case holding her after she completes treatment, contact my office and we'll figure out. Yes. to the arraignment in this case?
Your Honor, we waive formal reading. My client stands mute. We ask that you enter a not guilty plea on his behalf.
And then having waived formal reading, standing mute, court will enter a not guilty plea. Then what do we want to do for this today?
Your Honor, if we can adjourn it for another pretrial, I still need to get digital discovery on this.
All right, will the 16th work for you?
Let me check. Yes, Your Honor.
All right. I'll adjourn the pretrial in this matter to September 16, 2026 at 9 a.m. As to bond in this case?
Your Honor, my client is gainfully employed. He works at the U of M hospital as a food server. He has retained counsel. He will be appearing at all court appearances. I am asking for a personal bond.
Where's the alleged BAC?
BAC in this case was 0.092. There's a prior high BAC from 2023 that's used to enhance. There was not a crash involved in this case.
All right. Bond in this case will be set in the amount of $10,000 personal recognizance bond. I'll order standard conditions, including no assaultive behavior, possession of any weapons, firearms, ammunition. I will order that the defendant not possess or consume any alcohol, recreational marijuana, or any illegal drugs. This time, I will order that the defendant is to report to the Department of Community Corrections for placement on a SoberLink testing device. You need to report to Community Corrections within the next 24 hours, sir.
Yes, Your Honor.
Thank you, Your Honor.
All right, thank you. Court calls case People versus Matthew Lee Myers.
Morning, Raymond Cook with the people.
And Assistant Public Defendant Nicholas Bukovich on behalf of Mr. Myers, who is appearing via Zoom.
Mr. Myers, can you state your name, please?
Yes, Your Honor. Matthew Lee Myers.
Thank you, sir.
At this time, Your Honor, I'll be requesting an adjournment to look into some additional video discovery as well as track some pending felony matters my client has.
September 16, 2026, 9 a.m.
Did the court receive a letter from the individual on the case? I received an email this morning and it looked like it was forwarded to me. The original said, "Dear Cedric," and related to this case. I wasn't sure.
Here, Cedric. Did we get something?
So
I did not see anything, so.
see something that said, from another county
That what?
address out of Edgeway.
Okay.
How that's getting printed off. That letter discusses some cases in this county as well as out of county involving this defendant and that individual. To verify the information provided in there, I want to let defense counsel and the court know there may be a written bond motion in the coming future, depending on whether those claims can be substantiated.
Got it.
And I will say, Mr. Cookie did forward me the email this morning. I will say I did begin to look into some of these matters, and I have a discussion with you because I do think some of these alleged bond violations were cases pending before my client was arraigned on these matters. So it does seem like the complaining witness in its felony matters is trying to reach out about these matters, but I do not believe there should actually be any bond violations based upon my quick review of the file.
So, who is this from?
This defendant has two pending felony stalking cases. That was the victim of those stalking cases who's reaching out as it relates to all of his cases.
Got it. Okay, well, I won't take the time to necessarily go through this at this point, but okay. I will indicate, I mean, the informality of how I'm addressed in this, I will just indicate to counsel should not be taken. I don't know who this individual is as I look at this. So.
No, understood, Your Honor. I mean, this could be a matter that could be addressed at his next GCC. That's a bit that'd be more relevant to that matter. However, I do know the cases that the person is citing that were as alleged bond violations of these cases where he was arraigned on and prior to him being arraigned on all Washington County cases. So I do not believe a violation does exist based on my reading.
No, I heard you the first time. So I'll adjourn this out to September 16, 2026, 9 a.m. Okay.
Thank you.
Thank you.
Thank you, Your Honor.
Thank you. Court calls case People versus Aisha Parker.
And Assistant Public Defender Nicholas Buckovich on behalf of Ms. Parker, who should be appearing via Zoom.
Aisha Parker. Nope.
Yeah, I did speak to Ms. Parker earlier this week, and I know she's been provided Zoom information. She attended to be here today, so I'll be asking for an adjournment.
Bench warrant will issue for defendant failure to appear. Bond will be set in the amount of $5,000 to give 10% privilege. Court calls the case People versus Brandon Peer.
Your Honor, Raymond Cook for the people.
Good afternoon, Assistant Public Defender Mark Perry on behalf of Mr. Peer, who is not present, Your Honor. I got a call this morning that he turned himself into 9th District Court on a warrant there. I did find the case in their court system. It does say on the ROA that today the warrant was canceled and it's scheduled for a bench warrant hearing at 9:30 this morning to verify that that information was correct. His mom sent me an email informing me of that. So that's the information I have on Mr. Pierce's whereabouts. She informed me that they did keep him. He wasn't just released. So I think he's in Wayne County at this point.
Okay. So I'll issue a bench warrant for defendant's failure to appear rather than adjourn it out.
I think, Your Honor, there is one for a community corrections violation.
There is.
Yeah.
So, well, you're right. So we'll leave the bench warrant out. I won't set a date. All right. Thank you. Court calls case People versus Sheridan Reed.
Your Honor, Raymond Cook.
Good morning, Assistant Public Defender Lauren Perry. Ms. Reed filed a motion on this case. We did not file it on her behalf.
Do I have a motion? But why would I'm not. It's a motion to destroy fingerprints and biometric data. And this case isn't concluded. Motion denied. What are we doing?
Your Honor, this case was dismissed at FSC a while back.
Was it? It is. So, okay, I see. This case isn't still pending. Looks a bit confusing in here. Miss Reed?
Yes.
So this case was dismissed, right?
Exactly, yes.
All right. Are the people going to have any objection?
Your Honor, I don't believe there's any legal basis for my objection.
All right. So I will grant then the destruction of the biometric data. And I've signed that over.
Thank you.
Thank you.
You're welcome. Can I ask a question, Your Honor?
Okay.
How about, I did this because I applied for a job at the hospital and I was denied. Is this process to get this off my record so I can see if I can still get the job, or is it a long wait?
Yeah, I think you're going to have to ask an attorney about that, ma'am, as well as I think the Michigan.
Okay. All right. Thank you.
Thank you. Court calls case People versus Kristen Stamper.
Good morning, Your Honor, Raymond Cook for the people.
Morning, this is Public Defender Lauren Perry on behalf of Ms. Stamper. Take your name now.
Kristen Stamper.
I have before me a plea form, and it will be pleading to the charge of assault and or assault and battery 92-day offense. And there is an agreement to a deferred sentence. That's the court's full understanding. I do not have the defendant's signature on this, however.
Oh, Your Honor, she did give me permission to sign it on her behalf. I apologize.
All right, I'll let you. Yes.
The correct statement of the agreement, Your Honor.
All right. While we do that, ma'am, can you raise your right hand? Do you solemnly swear or affirm testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
State your name.
Kirsten Stamper.
All right. You can put your hand down. Ma'am, it is this court's understanding that you're going to be pleading guilty to the charge of assault and or assault and battery.
Yes, sir.
That's a misdemeanor, punishable by up to 93 days in jail, $500 fine plus court costs. You understand that?
Yes, sir.
You understanding that? You still wish to plead guilty?
Yes, sir.
To that charge, how do you plead?
I'd plead guilty.
Now, you understand that by pleading guilty, you'll not have a trial of any kind.
Yes, sir.
You signed or caused to have signed on your behalf an advice of rights form, is that correct?
Yes, sir.
You have any questions regarding any of those rights?
No, sir.
All right. You understand that you're waiving or giving up all of those rights, inclusive of the rights that are contained in paragraph 5.
Yes, sir.
You understand you're giving up your right to appeal upright.
Yes, sir.
Are you on probation or parole?
No, sir.
Has anybody promised you anything other than what's been stated here today to get you to plea?
No, sir.
Anybody threaten you or coerce you?
No, sir.
You're doing this voluntarily and of your own free will?
Yes, sir.
And also because you believe that you are indeed guilty of this offense?
Yes, sir.
On the date of August 8th, 2025, at the location of 2380 Carpenter Road in Pittsfield Township, Washtenaw County, State of Michigan, were you involved in an altercation regarding with an Israel Manj?
Yes. So
Okay.
we were barbecuing. We were barbecuing outside. I was pregnant with my second daughter. And Israel got disrespectful. He was smoking weed with my child's father. Mind you, he was only underage. And he looked at me and called me the B word. And I said, please don't call me that. And mind you, I was going through postpartum at the time. I was distressed, going through a lot. He was being mouthy, so I got up and slapped him one time. It wasn't multiple like he had told the police officers. It was just one time with my right hand.
Okay. You didn't have his permission to do that, did you?
No, sir.
You slapped him, and when you slapped him on purpose?
Yes, sir.
All right. Ma'am, if I accept your plea, between the time of my acceptance of your plea and the time of sentencing, if you commit misconduct as defined under the Michigan court rules, you would not be entitled to withdraw your plea, and the court would not be bound by any sentence evaluation or recommendation. You understand that?
Yes, sir.
Counsel aware of any other promises, threats, or other inducements which have led to this plea?
None from the people.
No, Your Honor.
And have I complied with the court rule?
Yes, Your Honor.
Satisfied.
Court will accept the defendant's plea of guilty to this charge. Defendant is referred to probation for a pre-sentence investigation and report and consideration of deferred sentencing. Sentencing in this matter will be October 14th, 2026, 9 a.m. Bond will continue. Ma'am, I'll need you to wait online, and we're going to put you with my probation department so we can begin the sentencing process, okay?
Okay, thank you, Mr. Simpson.
Thank you. Court calls the case, People versus Tepe Terry.
Your Honor, Raymond Cook for the people.
And Assistant Public Defender Nicholas Bukovich on behalf of Ms. Thierry, who is appearing via Zoom.
Tepe Terry. Ms. Terry.
I did see her on earlier.
Oh, I
One
see her.
second, I'm sorry. My connection.
All right, I'll
Sorry.
need a camera, man.
Hello.
Hello, state your name.
Hi. Tepe Terry.
All right, she's here. What are we doing?
I was gonna be asking for an adjournment of this, Your Honor, to look into some additional video discovery.
All right, I'll adjourn this matter then to September 16th, 2026, 9 a.m. Bond will continue. Thank you.
Thank you, Your Honor.
Court calls case People versus Serenity Thomas.
Good morning, Your Honor. Raymond Cook for the people.
And Assistant Public Defendant Nicholas Bukovich on behalf of Ms. Thomas, who's also appearing via Zoom.
Serenity Thomas?
Yes.
Okay, you got her. Okay. What are we doing?
I'll be asking for an adjournment, Your Honor. She's working on paying off some tickets. She paid off a ticket this week. She is just waiting for it to post. So she's working on reobtaining her license.
Adjourn this to October 7th, 2026, 9 a.m.
Thank you, Your Honor.
Thank you.
Court calls case of the People versus Jamani Vanderloop.
Morning, Your Honor. Raymond Cook for the people.
Good afternoon, Assistant Public Defender Lauren Perry on behalf of Mr. Vanderloop. Not checking Zoom.
Not checked in.
Yeah, I didn't speak with Mr. Vanderloop. He told me he was coming in person. I don't have an explanation for his better to appear.
Did? All right. Bench warrant will issue for defendant's failure to appear. Bond is set in about $5,000. Give it 10% privilege. That warrant will issue immediately. Court calls the case of the People versus Vonai Williams. Vonai Williams, probably.
And Assistant Public Defendant Nicholas Bukovich on behalf of Ms. Williams.
Vonai Williams. Not here.
Your Honor, I did speak to her earlier this week. I did provide her the Zoom information. I would be requesting an adjournment.
And this will be twice now that I guess I'm arguing with the defense as opposed to against them. I received documentation that just shy of being that I would be willing to dismiss this case. I just need something with the name on it to prove that the documents belong to the defendant. So I wouldn't be objecting to an adjournment, given how close we are to an ultimate dismissal.
Is that two for Bukovich?
The first one wasn't me, Your Honor.
Which was it?
It was Mr. Kirwald.
Same thing. All right. I'll adjourn the matter. How long will it take you to get that information? You just need something with a name. 16th.
Yes.
September 16th, 9 a.m. Bond continued.
Yeah.
Defense superhero Cook. Court calls the case People versus Daniel Worth.
Morning, Your Honor. Raymond Cook for the people.
Good morning, Assistant Public Defender Lauren Perry on behalf of Mr. Worth. Mr. Worth, state your name.
Daniel Worth.
Thank you.
I was going to interrupt for plea negotiations, please.
That's all in addition to the immigration holder. It's my thought, Mr. Quinones Diaz, that I'm going to go ahead and sentence you right now. Okay. Ms. Nicholson, anything on behalf of the state?
Your Honor, other than what you just indicated, we would ask that there be a prison sentence imposed based on the conduct. Defendant did absolutely everything he could to try to not be detained on the evening of July 19th. It is clear that he poses a risk to the community, and we believe a prison sentence is necessary and appropriate.
Do you have a jail time credit?
He's been in since the 19th, so I'll work on calculating that.
All right. Ms. Diefenbach.
Well, you caught me unawares, Judge. I didn't anticipate this. Because I did not discuss that possibility with him.
I don't see the point of, there's just simply no way that I can place him under community control. Even with his prior record, but with the number of holders and warrants he has outstanding and the likelihood that he's going to be deported, I'm guessing. That's what it looks like to me.
Your Honor, it also indicates when his record is run that he has, back in 2023, I believe, I'm trying to pull it up again, that an immigration court found that he was inadmissible.
I see that, Station Eagle Pass,
Yes.
Texas. Yeah, I see it.
There was some kind of proceeding back then. He has 46 days of jail time credit as of today.
Mr. Quinones Diaz, is there anything you'd like to say before I sentence you?
I should say, that when I talked with him, I did not have an interpreter, but he and I were able to communicate that it had been a really bad day, and I do know he consumed a great deal of tequila. And so I'm not too sure. I know he has family in the United States and he has family in Colombia, both.
Okay. But you would agree that based upon the information that the court has at this time, that he has been deported in the past and determined to be, he has a designation of inadmissibility under the immigration laws?
Yes, sir. I understand.
Do you agree with what I'm seeing?
Yes.
Okay. Again, Mr. Quinones Diaz, I'll give you the one more opportunity. Is there anything else you want to say?
Just that I was not aware, Your Honor, that I had been considered inadmissible, based on, whatever immigration had deemed on that particular case. I wasn't aware.
Okay. I guess my question is, do you anticipate that you're going to be deported on this new stuff?
Yes, sir.
Okay.
Yes, sir.
All right.
Do you think so?
Okay. All right. The court has considered the statements made here today, the purposes and principles of sentencing, the relevant seriousness and recidivism factors. I am going to find that you are not amenable to community control and that prison is necessary to fulfill the purposes and principles of sentencing, including punishment, deterrence, and protection of the public. Probation would not only not adequately punish you, but it would be impossibility due to all of the holders and the likelihood of you being deported. I simply can't have someone supervise you, okay? And certainly the prison is necessary for protection of the public. So on count one, I'm going to order you to serve 6 months in prison. On count two, I'm going to order you to serve 12 months in prison. That to be served concurrent with count one, same time. On count 5, I'm going to order you to serve 180 days in the Warren County Jail. By law, that must be served concurrent with the 12 months. And on count 5, 180 days, I'm sorry, count 6, 100 days in the Warren County Jail, that also to be served concurrent. I will assess the mandatory fine on the OVI charge, $565. That's I'm going to suspend your operator's license for a period of 3 years. That will be effective today's date. And the court will otherwise find you indigent for the purpose of any fines, costs, or other financial sanctions. You have 46 days jail time credit as of today. Now, you are also subject to a discretionary period of post-release control, which means upon your release from prison, the adult parole authority may supervise you for up to 2 years. If you violate those rules of supervision, the adult parole authority can return you to prison for up to 1/2 of the court's original sentence.
regresar a la licencia y que los términos de ese programa por hasta la mitad del término original impuesto de sentencia.
If you commit another felony,
Comete otro delito,
you can be returned to prison for 1 year or the period that you have left on PRC, whichever's longer. And that time would run consecutive to any additional prison time that you receive.
sería algo, un término que estaría sirviendo de manera concurrente con la sentencia original, más el tiempo que se le representa.
You do have a right to appeal the court's decision of your sentence.
Claramente usted tiene derecho de apelar
If you want to appeal,
esta sentencia.
you must file your notice of appeal within 30 days.
30 días del momento de la resolución de esta sentencia.
Anything you need for your appeal, the transcript or anything else, including an attorney, if you cannot afford one, all of that can be provided to you at no cost. Do you have any questions for me, sir?
¿Usted alguna pregunta para mi señor?
Ms. Nicholson, anything else?
No, Your Honor.
Ms. Diefenbach?
No, sir.
Best of luck to you, sir.
Eso es todo el día de hoy, señor. Buena suerte.
Yes, well work.
I'll adjourn.
Mr. Gibbs, Ms. Nicholson, on behalf of the state of Ohio, we're here for sentencing. Everyone's reviewed the PSI, correct?
Yes, Your Honor.
Yes, Your Honor.
Ms. Nicholson, anything on behalf of the state?
Your Honor, the defendant has a history of failing to comply with orders of this court. He was in fact released in May by this court to continue in his treatment. That was not successful. He did not appear for his sentencing in July. His bond was revoked, and it's my understanding he has tested positive for something he does not have a prescription for. We do not believe he is amenable to community control at this time and ask that you impose a sentence of incarceration.
Anything from probation?
Nothing further, Your Honor.
Mr. Gibbs?
Yes, Your Honor, I'd just like to note, my client is 41 years of age. He has 22 days of credit. He was compliant with the PSI for some interview process that occurred earlier. I would note one thing from his PSI treatment, just because oftentimes we don't see this, but he does acknowledge on the 1 to 5 scale as being a 5 out of 5 in recognizing the need for treatment in his life and that he has a serious issue with addiction and substance abuse. That as well, I'd also like to note that the PSI also reflects that he has quite significant and several quite significant mental health diagnoses, which oftentimes interplay with these substance abuse issues. We'd respectfully request the court to take that into account in discussions with him. He's apologetic and acknowledges that, and forgive me, the name of the sober living place where he was located, but that they changed their policy concerning MAM or medication. I'm botching that. I apologize. MAT, medication assisted treatment, and therefore requiring him to either very swiftly come off of it or to self-discharge. And he self-discharged again. He did not comply. He didn't come straight to pretrial services, and he absconded. We acknowledge that, but just wanted to share those facts.
Your Honor, he has 31 days of jail time credit.
Thank you. Mr. Masterson, is there anything you'd like to say, sir?
Yes, Your Honor. I do apologize to you and to the court. When I was discharged from the program, I was kind of at a loss. It happened pretty abruptly, and there was no wrongdoing. It was just, I guess they were having some issues with other clients, and I made a bad choice, and I was trying to seek other treatment, and the one that I was going to didn't wind up working out, and this happened the day before my court date, and so I don't have a vehicle nor transportation, and I wasn't able to come down here. I wound up on the streets. I had a relapse. I wound up in the hospital. I had some lesions on my leg, and spoke with them, and they recommended to me that I do like a restabilization of my treatment. So I was assessed by DeCoach of the OR, the Ohio Recovery Campus in Dayton, and they were awaiting my availability date. I've had this problem for a long time. I've embarrassed myself and my family, and I'm really trying to get it right. And I keep hitting hiccups, and I know I have to, own up for what I've done. I can only ask if I have any jail time, if I could be done locally, so I can stay in contact with my pastor, Rick Huff, and my worship team at my church, so they can do visitations with me.
Mr. Masterson, this is the third time that you've been before me. Back in 2021, almost the same set of facts. You were found overdosing. Back then it was you had a number of charges. Heroin was one of the ones that you had back then. But what concerns me is the court gave you opportunities for treatment. You had 2 violations filed against you while you were on supervision then, and then finally, in one of the times I put you through CCC. There's the list of opportunities that you've had and the number of treatment facilities that I've placed you into, and this isn't the first time that you've voluntarily left. Back in 2021. You left Fresh Start Behavioral Health against staff advice on September 9th of 2024. And I let you end up serving out local time on that case. Then in Then in 2022, you were before me for stealing a guitar. I'm sure that was drug related. Agreed?
Yep. Yes.
Yep. Yeah. Again, I placed you into community control. And once again, you failed to comply with the terms and ultimately were terminated from community control and allowed to do local jail time. Have you been to prison before?
Yes, a long time ago.
Well, I don't see, these other 2 cases are all within the last few years. I do not see how I can continue to pump resources in you when I put you in treatment. I let you out on bond in this case, put you in treatment, and you walk away. I mean, if you really wanted help, you wouldn't be doing that. So I'm going to make a finding today. Well, first off, I've considered the pre-sentence investigation, the purposes and principles of sentencing, the relevance, seriousness, and recidivism factors. I am going to find that you are not amenable to community control and that prison is necessary to fulfill the purposes and the principles of sentencing. Probation would not adequately punish you, and based upon your failure to respond to previous community control sanctions, I cannot in good conscience place you back into community control. So I am going to order you to serve 6 months in prison. You'll get credit for the 31 days you've already served, and the court finds that you're indigent for the purpose of any fines, costs, or other financial sanctions. You're also subject to a discretionary period of post-release control, which means that when you are released, the adult parole authority may supervise you for up to 2 years. If you violate that supervision, the adult parole authority can return you to prison for up to 1/2 of the court's original sentence. If your violation is that you commit another felony, you can be returned to prison for 1 year or the period that you have left on PRC, whichever is longer, and that time would run consecutive to any additional prison time that you get sentenced to. You do have a right to appeal the court's decision of your sentence to the 12th District Court of Appeals. If you want to appeal, you must file your notice of appeal within 30 days of today's date. If you can't afford to pay for the transcript or anything necessary for your appeal, including an attorney, that can all be provided to you at no cost. There may be opportunities for you to receive up to 1 day per month for participating in certain education programs sponsored by the Department of Corrections. Do you have any questions for me?
Yes, Your Honor. Well, I don't know if I should note, I'm on the MAT medications, also here at the jail. I just,
You want to know whether you'll be able to do that while you're in prison?
Yeah,
Only answer I can give you is I don't know.
Okay.
Okay? Because I don't know. I don't control.
I just didn't know if that needed to be like put on the record.
It's not something that I can order.
Okay.
I don't control the Department of Corrections. I sentence you to their custody. So right now, the sheriff's office is going to transport you to the Department of Corrections, and what they allow or don't allow is not within my purview. Okay?
Okay.
All right. Best of luck to you, sir.
Thank you, Your Honor. Thank you, I appreciate it. This way.
2026, 9 a.m. That's the last adjournment. Ron continued. Courthouse case, People versus Darius Butler.
Morning, Your Honor. Raymond Cook for the people.
Oh my God. All right. Sir, you are before the court on a misdemeanor citation that alleges that on or about 22nd, 2026 at the location US 23 near Michigan Avenue in Pittsfield Township, that you operated a motor vehicle that was unregistered. Do you understand that, sir?
Yes. Your Honor, may I interrupt?
Yes, please, because I saw it's a tractor. What?
I saw proof of registration, and I'd be moving to dismiss.
You have any objection? No. Okay. Sir, this case is dismissed. Have a great day.
Thank you.
Says driving a Peterbilt tractor. Court calls the case, People versus Morgan Clark.
Morning, Your Honor. Raymond Cook for the people.
Morgan Clark. Again, all right. Bench warrant will issue for defendant's failure to appear, bond set the amount of 5,000, 10%. Warrant will issue immediately. Court calls the case of the People versus Precious Clerk.
Morning, Your Honor. Raymond Cook for the people.
Hello, what's your name?
Precious Clerk.
Oh. Ma'am, you are before the court on a misdemeanor complaint that alleges that on or about July 15, 2021, at the location of 2000 Waters Road, I believe that being Target, that while you were an employee or otherwise a agent of Target, that you did embezzle from Target $200 or more, but less than $1,000. Do you understand what you're charged with? Yes? Okay, that is a misdemeanor. It's punishable by up to 1 year incarceration, a $2,000 fine plus court costs. The fine could be increased to 3 times the value of the property taken. If that's greater than $2,000, that would become the maximum fine. You understand that? Yes? You have to speak up for me. All right. All right. First question I have for you, ma'am, is do you wish to be represented by an attorney?
Yes.
Yes?
Yes.
Okay, this becomes a public defender case.
Good morning, Assistant Public Defender Lauren Perny on behalf of Miss Clerk. Miss Clerk's last name is now Watson. I'm not sure if court needs to know that. We wait for him reading the stand.
Happy about that?
The clerk is my previous marriage last name. So divorced.
Divorce? So that's why I asked. She happy that it's changed?
Satisfied.
Okay, good enough.
That's good.
I just thought, what are you looking at me like that? I just asked. You ask a question, everybody's critical. What? I was just trying to make sure she was happy. Jeez, oh, Pete Allen. Thunder Clerk. here, I will
Sorry.
indicate, well, we'll just leave it at that. Okay. All right.
I did wait for Maria to stand mute.
Yes.
I will,
Wait for reading standing mute. Court will enter not guilty plea.
I would ask for another pretrial date. Miss Clerk Watson is expecting, her due date is the 22nd, you said. So I'd ask for,
I mean, set it that date.
I mean,
Yeah.
you could come on Zoom, bro.
Look at this. Oh.
Just do the 22nd.
Yes.
So I'd ask for the
Son was born the 21st. I'm sorry, I digress. Go ahead. What?
I would just ask for the furthest date, Your Honor, given that she'll have a newborn at home.
And
No, if you're like me, you won't be sleeping very much. I'm not sleeping very much right now.
so that with both my kids.
Okay.
All right, yeah, I need to stop right here. Stop there. No, I was awake with them. Got up. I don't know. Nobody believes me? What up? All right. I'll review of little faith. I'm describing my life as a father.
Kids running around in the middle of the night.
Yep, kids running around in the middle of the night. That may be my first problem.
First,
Third.
third. So you know what's due. She could definitely come on Zoom.
See, you could say that. I'm not saying.
Third, this is gonna be like a little break for you in the hospital.
So that's fine.
No, I'm just joking. You got things to do.
Hey, here's what I'll do. Hey, she's due the 22nd. What's my latest date in October? What do you mean I only have October 7th? How does that happen? I heard you.
So November 4th.
I know that's far.
Yeah, that's far too.
Yeah. I mean, we could do the 7th, but
See, now the problem, they're staring at me. If I don't do that,
Oh,
they're going to say, how can you be so mean?
yeah.
Section a week later, maybe.
I mean,
why are you staring at
isn't further is better, but I'm like,
Oh, this is a 21 case. I'm going to November 4th, 2026 at 9 a.m. I'll set her bond at a $5,000 personal recognizance bond, standard conditions, including no assault of weapons and firearms, no alcohol, recreational marijuana, or any illegal drugs, and no going to any target in the state of Michigan. You probably shop there. You got,
I do.
right?
Yes, not that one, but
Well, but this would cover the whole state. I'm just not going to order get a baby. They get good sales.
I'm gonna text you right now. And you'll have my number. Okay.
okay.
Good luck.
And congratulations.
Yeah.
And nobody believes that I was, well, never mind. Talk about it later. Court calls the case, people versus Andre Fashion. The arraignment without counsel. Defense warrant will issue for defendant's failure to appear. Bond set in the amount of $5,000, 10%. Court calls the case of the people versus Katie Joe Strauss.
Morning, Your Honor, agreement for people.
Okay. Your name?
Katie Ostrowski.
Last name?
Ostrowski.
Ostrowski, okay. Ma'am, you are before the court on a misdemeanor complaint that alleges that between the dates of August 31st, 2025 and October 9th, 2025, the location of 7,000 East Michigan Avenue in Pittsfield Township, that being the Walmart, that while you were an agent and or employee of Walmart, that you did embezzle funds less than $200. You understand the nature of that charge?
Yes.
That is a misdemeanor, punishable by up to 93 days in jail, $500 fine plus court costs. Fine could be increased to 3 times the value of the property taken. If that's greater than $500, that would become the maximum fine. You understand that, man?
Yes,
First question I have for you is, do you wish to be represented by an attorney?
I do.
Public defender case.
Yes, Your Honor. Assistant Public Defendant Nicholas Bukovich. At this time, Your Honor, as it relates to the charge, we will waive formal reading, standing mute.
Defendant have a waive formal reading, standing mute. Court will enter a not guilty plea. You're looking for an adjournment.
Yes, Your Honor.
Trial in this will be adjourned to September 16th, 2026, 9 a.m. As to bond in this case, I'll set bond in the amount of $5,000 personal recognizance bond. Although there are standard conditions, including no assaultive behavior, possession of any weapons and or firearms or ammunition. And that, ma'am?
Yes.
I will indicate there's to be no possession of any alcohol, recreational marijuana, or any illegal drug. And at this time, I would also indicate that you're not to go to any Walmart store in the state of Michigan. Understand that?
Yes.
All right. Thank you.
Thank you.
Court calls case People versus Doris Williams.
Sorry.
Ms. Williams? Can you unmute? Ms. Williams? Okay, there you
Yes.
go.
Yes, how you doing, Judge?
I'm doing well. Can you state your name for me?
Doris Williams.
All right, Ms. Williams, you're before the court on a misdemeanor citation that alleges that on or about July 19, 2026, westbound I-94 in Pittsfield Township, that you operated a motor vehicle without security. Basically, you operated a motor vehicle without insurance. Do you understand what you're charged with?
Yes, sir.
All right. That is a misdemeanor punishable by up to 1 year incarceration, a fine of not less than $200 nor more than $500 plus court costs. Do you understand that?
Yes, sir.
All right. First question I have for you is, do you want to be represented by an attorney?
Yes.
Okay. It's a public defender case.
Your Honor,
Yes, ma'am.
this was all new to me. I was operating a car, but it was not my car.
Okay. All right. Hold on, Ms. Williams. I'm going to give you an attorney. I don't want you saying anything about the case this time, okay?
Thank you.
All right. This is a public defender case. Go ahead, Ms. Perry.
Assistant Public Defender Lauren Perny on behalf of Ms. Williams will waive formal reading and stand mute to the charges.
Defendant having waived formal reading, standing mute. Court will enter a not guilty plea. I will adjourn pretrial in this case to October 7th, 2026, 9 a.m. I'll set her bond at a $5,000 personal recognizance bond, standard conditions, no assault behavior, no possession of any weapons, no alcohol, recreational marijuana, or any illegal drug. Okay. All right. Do you have contact information you need her to call?
Your Honor, if I could confirm, Ms. Williams, are the last 4 digits of your phone number 4303?
Yes.
Okay.
All right, I have a number.
All right. Very good. Okay, Ms. Williams, we'll see you in October, okay?
What's the date again?
It's October 7th.
Is that,
2026 at 9 a.m.
is
But
that
you'll
by
be in
Zoom?
contact with your attorney they'll let you know exactly what time you have to show up on that date, okay?
But is this by Zoom?
They will take care of that for you.
Okay, thank you so much.
You're welcome.
All righty.
Take care.
You have a good day.
You do the same. That's it for 10 and 11, so we're on 12. Should I just keep on? Nope, I'm gonna take a break. For standing recess.